Good morning. Happy Tuesday. It's time for coffee and Cursey words. But because I've been up for so long, I've already finished my coffee. I've moved directly onto water. But yeah, that's what's happening today. We have a lot to cover today. A lot's been going on. We are going through Ethan Klein's first win. Well, I guess second win against Triller and what's going on with those other cases. We're going over the saga that is the Tati Westbrook business partner lawsuits. And then I don't know if you're watching Real Housewives of Beverly Hills. I know a lot of you wanted a pause from what's going on with the Girardis. Don't worry. It's its own podcast episode for tomorrow. But new housewife Diana Jenkins sent out a fleet of cease and desists, and I have those for you today, and we are going to go over those. And there's some tea. There's some tea in those. So with that, we should get going. I will absolutely be putting the timestamps down below. So replay crew, love you. And then we will be talking about everything that went down in Vegas. Not everything. Some of the things that happen in Vegas stays in Vegas. We will be talking about the things that are publicly disclosable before we get to Q&A, because I know some of you want to see the topics and some of you are like, girl, tell me what lawyers you were hanging with. There were so many. The lawyers took over Las Vegas for like 5 days. So I am just, you can hear it in the voice. You can hear it in the voice. I sound like I've been in Vegas for 5 days. Why? Because all of the networking events had like music. Why do you have a networking event with a live band? Like, I can't talk over a live band. Oh, it didn't mean I didn't try. So we were just, we were trying to talk. And when I try to project over loud noise for too many days in a row, I end up a little raspy. So we're just leaning into raspy Emily today, and it's going to be great, I think. We're going to hope. Who knows? Exhaustion makes for interesting live streams always. And if the voice gets too bad,
I suppose we could just do this because it doesn't sound raspy at all.
So, there's zero regrets. I have zero regrets about anything in Vegas. It was really a great conference. I will talk about it before we get to, FAQ and find out. We will absolutely get to it. And with that, we should just go. I should roll the intro and we should actually start the show. Those are our 3 topics today. We're going to leave lots of time for questions. I'm already getting hype about the Apple event tomorrow. I'm so hyped that it wasn't on a Tuesday because of the long weekend. I'm so excited that it's on a Wednesday so that we can do this. And then tomorrow I can go watch the Apple Live event. I'm ready for new iPhone. It's iPhone season. It's tech season. It's like we're in the ramp up to Techtober. I'm ready for it. But anyway, before we do that, where is my live stream opener? Yeah, let's do that. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. We are going to start today talking about the Ethan Klein Triller saga. I'm just pulling those documents up for you now because A, I want to show you what happened, but B, it's because we talk about slap motions and anti-slap motions so much. And, this is an example of what happens when you bring a lawsuit that could actually be slapped. Slap means strategic litigation against public participation. In some states, slap only really goes to like political petitioning and participation. In other states like California, you get a much broader slap statute that goes to speech in general and participating in public forums in general. And that is a really much larger statute that has much bigger implications and consequence. And we've seen that in case after case we cover. Why? Because I cover pop culture here. And what happens the most in pop culture right now, it seems to be defamation. Emily, do you just cover defamation? No, but it feels like it because so many of the cases that we cover involve defamation, just because that is the world of the celebrity. And I think we're going to keep seeing these things grow. I think as we see kind of a continuing, and I hate saying cancel culture because it's not really that, but as we see a continued kind of outrage culture where people are instantly heated or passionate or like, we're done. We see these allegations and we're done. I think we're going to see more celebrities like Johnny Depp suing over defamation to rebound their reputation because allegations can be so damaging. And waiting for the court of law is not always what happened. Waiting for the court of law takes years. People tend to react on the initial before they get to what all of the facts are, because we always hear one side of the story first. And that is always an interesting thing. So I think we will see more and more defamation cases. Are we going to continue covering it here? Of course we are. It's social media. Where are the boundaries? And especially when we get to social media that interacts with YouTubers and kind of non-traditional celebrities is because I think YouTubers are just as much celebrities as anybody else, but these non-traditional celebrities, we're going to see it from them too. And that's what we saw with the Ethan Klein case. It's what we're seeing in the Tati Westbrook case that we're covering today too. All of these have defamation elements to these cases, if not defamation causes of action. So a brief road so far with Ethan Klein, Triller, Cav, and everybody. Lord. Ethan Klein from the H3H3 podcast commented and gave commentary on, my cat is just like, okay, buddy, you've got space. He is just making himself the most comfortable creature in the world. Both of my cats are trying to like shove themselves under my monitor where I'm streaming, and it's a mess over here. I'll take a picture and share it later. Ethan Klein from the H3 podcast, huge creator here on the platform, gave commentary on the Jake Paul Askren fight like 4 or 5 days after the fight, made jokes about not paying for the fight. Triller was at that point, Triller Fight Club, not the Triller My Shit's Flipped app that's a competitor to TikTok, was going after just about everybody who streamed the fight. It seemed that the fight didn't perhaps perform as well as they had anticipated or whatever. The clips of the end of the fight were on Twitter like right after the fight happened. Anyway, Ethan gives commentary on the fight days after the fight. He had taken clips of the fight that were available on the internet, re-uploaded them to a kind of separate YouTube channel where they were not public to use those clips for his podcast. Then got sued for copyright infringement for restreaming the fight. I don't think it's a restream. I've covered that case. It's still pending on a motion to dismiss. That case, Triller got all trillery. And that federal case was kind of a mess. They sued H3 like 3 or 4 times in that because they didn't sue them originally, and then something got dismissed, and then they tried to sue them again, and they had improperly joined people. Mess. Then Ethan Klein, goes in on Triller, who owns Triller, and starts going in on Ryan Kavanaugh and reports from Ryan Kavanaugh and about Ryan Kavanaugh from the past, from a variety, from Variety and other publications, and starts really leaning in like, oh, you're going to come sue me? Cool. Let's talk about Triller. Let's talk about It's Flipped. Let's talk about what you've been accused of. Let's talk about all of it. So then Triller, the company, sues Ethan Klein, his company, the clothing company, and all in state court in California for interference, really over brigading of reviews on the Triller app on the App Store and the Google Play Store. Triller did not do a good job of proving this. The case got dismissed at the anti-slap stage. Anti-slaps in California stop litigation early on. There are some that are not big fans of anti-slap because you don't even get to discovery. Had the Johnny Depp Amber Heard case been in California, it probably wouldn't have gone to trial. The thing that was I think still was the most powerful with regard to the Washington Post op-ed was the testimony from the attorney from the ACLU. I thought that was some of the most powerful testimony about what the article meant, what they were trying to do with the article, the impact. But if this case, if the Depp case had been dismissed at that early stage on an anti-SLAPP in California, they never would have gotten that discovery. So again, that strategic litigation against public participation, that anti-SLAPP motion is a terminal motion to dismiss. So it's a special statute that gives you special grounds for a more powerful motion to dismiss that cuts your case off at the knees before it even gets going. It's meant to stop people with money from harassing people who are speaking, book publishers, journalists, things like that. But now that extends, because microphone and internet connection, that extends to anyone who's speaking, really. And the anti-SLAPP can really cut off a litigation at its knees, which is its point, to not cost someone the expense of litigation if really it's a bullshit suit to silence someone who's properly exercising their rights of speech or public participation. So with that, that's kind of the overview of the anti-SLAPP statute in California, but it does stop the litigation where most motions to dismiss, you get a motion to dismiss and then you have the opportunity to refile it. In the anti-SLAPP, it's done. And there's provisions in California and other jurisdictions for attorney's fees. And that's what we're seeing here. So Triller sues a whole fuck ton of people, and the federal judge, probably my favorite federal judge at the moment, because he was like, bro, no. I love that motion so much. If you have not watched that episode where the federal judge on his own slaps down Triller's lack of joinder, I will have to find it and link it. It's probably still one of my favorite judicial rulings ever. The judge was like, literally, you can't do that, WTF. It was great. So federal case still pending with regard to copyright for the fight. Triller gets all pissed off because the foot soldiers are saying hurtful things on Reddit, and then there are lots of one-star app reviews. They can't necessarily connect it with Reddit. And again, how do you hold a creator responsible? And these are larger questions for the internet as we continue to move forward with the internet. At what point are creators responsible for what their audience does? And this case is Triller trying to say Ethan Klein's responsible because people are leaving one-star reviews in the App Store. And the court's like, yeah, but you had other one-star reviews in the App Store. So that is the state case. Then, as I see it, then as it's obvious that the Triller lawsuit against Ethan Klein, H3 Productions, the clothing company, and all the rest of it, as it's clear that that is going down in flames, like it's going down. Like we were up here yelling timber with that lawsuit. As it was clear that that was going down, Ryan Kavanaugh, who may or may not look like Harvey Weinstein, according to the website, sues Ethan Klein for defamation in a third lawsuit between the two of them. So then we get the other suit. That's the one that talks about all the internet tea. Like, I appreciate it. I appreciate the way that lawsuit's written. I'm sure Ethan doesn't appreciate the lawsuit because now it's a third lawsuit. This all still costs the parties involved a ton of money. This is still expensive. It's still a giant pain in the ass. It's still bordering, I think, on harassment. Samantha says those Reddit memes in actual filings still make me roll laughing. Yeah, the Reddit came into the filings. The problem is this, you make a great point, Samantha. The problem is traditional media and traditional attorneys do not understand internet communities. And they don't understand that if you are going to put Reddit posts into your filing, Reddit's not going to stop Redditing. It's going to double down. It's going to double down on the Redditing. Because if you're on Reddit, you're going to be like, I want, or maybe not you particularly, but some will be like, I want to be in the lawsuit filing. So let's see what we can say. Because, you know, free speech, you're allowed to say mean shit on the internet. Not everyone agrees with it. We don't always like it, but you're allowed to say mean shit. You can't say defamatory shit, but you're allowed to say mean shit on the internet. And people were, you know, the memes actually, not all of them were that mean. A lot of them were quite funny, but Reddit was Redditing. It ends up in the filing. And then when you keep shaking that hornet's nest, it's just going to get worse because traditional media and traditional Hollywood and these lawyers don't understand internet communities. So when they came for Ethan Klein, I don't think they understood that Ethan Klein is not just some dude on YouTube. They didn't understand the power and connectedness of a very large community that's like, oh, fuck us? No, nobody. Fuck you. And that's where they really just fail in these types of cases. I mean, we saw it just recently. BitBoy Crypto should have known, because YouTuber should have known that when he sued Atuzi in that complaint that said my feelings were hurt, that it was going to be a thing. It was going to be larger than he anticipated it to be, because internet communities. And what do we love on the internet? We love nothing more than to talk about the internet on the internet. We love it. So, if you have not watched my whiskey stream where I break down the Cav versus Ethan Klein lawsuit that does talk about Keemstar's penis and Trisha Paytas, that's a stream to go watch. I mean, don't forget to do the likey and subscribey things here. I know some have been like, oh, we don't just talk about Depp versus Heard 24/7. No, we don't. There's other things to talk about. So those of you that want to talk about all of the law, don't forget to do the likey, subscribey things. But if you have not watched that stream, that lawsuit gave me the giggles. It was pretty funny. They threw all of it in there. It's amusing. That one's not done yet. It's still pending its motions to dismiss. So, with the Triller Klein state case, the brigade, I'm calling it the brigading case because it's really over the people left 1-star reviews. That case, oh my God, this is killing me today. People left 1-star reviews. That got dismissed on an anti-slap properly. The court went above and beyond to give Triller space and grace, and they still could not make their case. So Ethan Klein wins legal fees. So now Triller has to pay Ethan Klein's legal fees. Let's go look at that ruling. I think that gave a good, thorough, maybe a little too much of a road so far. Kevin asked, did you see Atuzi's video talking about the lawsuit and it being shut down? I did, Kevin. I should have quick bitted it today. I'll quick bit it again on Thursday. But I went and pulled the filing about BitBoy Crypto dismissing it. I'll talk about it on Thursday because BitBoy Crypto was like, I'll talk about it Thursday. I'll talk about it now. BitBoy Crypto was like, I didn't think it would be public. It's a lawsuit. It's not just a motion to it's not just a cease and desist with a filing attached to it. Sometimes when we get to cease and desist, I'll address it. Somebody remind me. Megalina, make a note. When I get to cease and desist, to talk about the way that you would use a lawsuit and a cease and desist that wouldn't become public, because I'll circle back to it. Kevin, I will circle back to it. That is the more appropriate way. Lack of sleep aggravates the ADHD. And I don't want to just literally be like, squirrel. But it might happen anyway. It just might. All right. Let us take a look at this win for Ethan Klein, August 30th, 2022, because of course everything happens. Nature of proceedings, hearing on motions for attorney's fees. This is after, of course, the anti-slap motion was granted. Pursuant to codes, here's the court reporter. Matter called for hearing. Motion for attorney's fees filed by Ethan Klein, Teddy Fresh, Ethan Klein, Ted Entertainment Inc. Ted being the company that runs the podcast. Teddy Fresh being the clothing company that's completely fucking unrelated to this. Also, Ela being completely unrelated to this, but they tried. They tried it. The court awards attorney's fees in the amount of $51,741 and costs in the amount of $4,611 for a total of $56,000. This was every single cent that they asked for. I also thought the attorney's ask was low. I think they could have asked for more. They might have billed for more. I think Ethan's attorneys really did great work in this and are continuing to do great work in this. So now Ethan has the unenviable position of having to enforce this order. And that's the thing people forget. Just because attorney's fees got granted doesn't mean you're getting a check tomorrow. They have to go ahead and try to now enforce this. Hopefully, Triller will do the right thing and just give them the attorney's fees, or they will figure out a like 3-part payment or whatever they want to do. And Ethan won't have to spend more attorney's fees to fight with this. But what's nice for Ethan is when they get paid, this can just go to the lawyers to keep fighting the calf case. It's like, thanks for paying me to continue to fight with you. And if he wins the anti-slap on the calf case, then he will have to, make another motions for attorney's fees. And that will be great. So this is the cost. And I appreciate that California did this. Again, there are times where I can see the difficulty with such a strong anti-slap. I can see that cases that maybe should go forward get cut off before discovery, and how can you prove some of the things you need? Anti-slaps are not granted just willy-nilly. You really have to have nothing and no expectation of finding anything at discovery. But it's why attorney's fees are part of this. It's literally the fuck around and find out of it all. It's like, oh, if you want to cost us this money, you're going to pay for it. So you better know. And in some jurisdictions, failure of the attorneys to properly advise about whether the case can be dismissed on an anti-slap can be something that the attorney can be held responsible for. So with that, we should get moving on. I saw somebody say, wait, Ethan got sued a lot. Ethan got sued a lot. Mostly by Triller. So yeah, mostly by Triller. Look, man, on the internet, sometimes it happens, but this is a don't know when to quit. This feels like there has been a very it feels personal at this point. So that's how it feels. All right, we need to continue on. And for all of you in the chat, if you are new in the chat, I'm just going to remind you that as I go through the topics, because I do get distracted, if you have questions for me when we get to Q&A, best time to ask them, because I don't always see the chat in real time as I'm covering topics. And when we get to Q&A, I'm going to get to as much as I can with Q&A. It doesn't just have to be on these topics today. So with that, let us move on. That was Ethan Klein. I think we're good with Ethan Klein. I think we understand he won attorney's fees. Hopefully he gets it paid by Triller. When he does, I'm sure it will be up on Twitter. So, Lauren S. said Ethan's poking the hornet's nest with Andrew Tate, apparently, which might get dicey. I mean, John Norris, why did Harvey Weinstein sue Ethan for defamation about Ryan Kavanaugh? That's a joke. It's a joke because Ethan Klein trolled Ryan Kavanaugh with the Does Ryan Kavanaugh Look Like Harvey Weinstein.com website. Look, traditional Hollywood, you don't understand the internet. You need to find attorneys that understand internet culture, internet communities, because of course Ethan started trolling Ryan Kavanaugh. Did that probably hurt Ryan Kavanaugh's feelings? Probably. But hurt feelings are not defamation. Defamation can also cause hurt feelings, but hurt feelings in and of themselves are not enough. All right. Raise your hand if you've ever had your feelings hurt by the internet. I mean, she doesn't even go here. The internet is basically just Regina George, but it doesn't mean it's defamatory. All right. Oh gosh. I'm like, what's faster? Housewives cease and desist or Tati Westbrook? Kevin, I was joking. No, I was joking. I was joking about Weinstein suing H3. Okay, look, I've just got to explain the joke. It was in the lawsuits. We're just going to have to explain. Look. I was actually talking about this with an entertainment attorney that has had cases with Ryan Kavanaugh. I was chatting about this in Vegas this weekend and actually showed somebody the website because I was explaining the thing I was talking about was you have to understand internet communities and you have to understand like fandoms, essentially. Like the foot soldiers are an Ethan Klein fandom. But internet fandoms are so different than anything else. And when people don't understand, they don't expect it that they're going to get trolled. So, oh, there's a new feature on the website. So this is a troll. Wait, no, I'm talking about the website. Shit. The website is trolling. I'm not saying that Ryan Kavanaugh is a troll. Damn it. You know what I mean? This website was created as a trolling website to ask the question and to poke fun. That is the point. Triller's deadline to pay $60,000 to Ethan Klein in attorney's fees, and then they've got the timer that was added. So there's a game, there's articles, and then there's this website. Does Ryan Kavanaugh look like Harvey Weinstein? This is Ryan Kavanaugh. This is a comprehensive analysis. The public is confused. And this is why the public is confused. So then they go through the website with sliders. And, Ryan Kavanaugh was maybe not thrilled with the association. I'm just saying. So then they built a game. This is what happens when you poke fun at the internet. This isn't a poke fun. This is a public service. I mean, it's a fair characterization. So founder, owner of Triller, and then they go through his timeline. These are all things that have been publicly reported. Look, somebody just put it in one place. This is all stuff that's been reported elsewhere. And on and on and on. Still can't tell the difference. Wait, there's a game. Hold on. They built a game. There's a game. Oh yeah, there is. Yep. Game. Hone your skills. See if you can determine Ryan or Harvey. Faster answers yield more points. Here, we're going to have to mute the song because, oh gosh. Okay, I don't know. I've never played the game. Oh, that's Harvey Weinstein. See? They built a game. That's Ryan. I actually can't tell them apart most of the time. I get a wet and reckless bonus. Oh, damn it. It was moving, y'all. It was moving. It's so difficult. All right. But with that, now that damn it, it's still going. Why are we still going? Oh, that's right. All right. Anyway, that is the internet. That's the website. The website was featured prominently in the defamation lawsuit. But again, asking the question is not defamatory. Nowhere has anyone said these two look alike. That means they're this. That's never, ever been connected. It is internet trolling, poking fun at Ryan Kavanaugh because his feelings get hurt. And then he goes wild on the internet and tries to get Ethan Klein reported to the FBI and shit. But also the thing that's been most interesting about Ryan Kavanaugh, Triller's got its own legal problems. We're going to get into Triller getting sued by Sony and all that shit Thursday, I think. So we're going to get into all of that later because Triller, the app, has its own legal issues that I have not even started to cover yet because we've been busy. But in addition to that, Ryan Kavanaugh, as a part owner of Triller, has been writing about why TikTok should be kind of yeeted from platforms in the US. And it's very interesting to see if TikTok is going to come after Kavanaugh personally, because is that tortious interference? Kavanaugh is a large owner of a competing app and is advocating for his competitor to be taken down. I've got some questions. He's trying to say that Ethan Klein and him do the same thing because they're both in entertainment. And he's directly advocating for his competitor to be taken down off of app stores in the US. Well, if it's taken off of app stores, the only competitor really is Triller. All the other competitors have shorts baked into other apps. Triller, it seems like, had the most downloads in the time period where it was unclear if TikTok would be removed from app stores. So I just have questions. I mean, if he wants to start shaking that nest, other people are going to do it to him. We should move on to Tati Westbrook. Because as we're talking about internet personalities, we should move on to Tati Westbrook. All right, let me pull up. There's so much. All right. I'm going to try to give a good road so far. Let us swoop and talk about the Westbrook litigations and see if we can get up to speed somewhat quickly, because this is like a 2-year saga at this point. Most of you are familiar with beauty guru Tati Westbrook, YouTuber here on the platform. There was a whole bi-sister scandal. Do we care? Some might. For our purposes, Tati Westbrook and her husband James Westbrook have had a falling out with their business partner Clark Swanson. Did I almost say Cluck? Maybe. With their business partner Clark Swanson. Business partner Clark Swanson sued them in California in October 2020. This was one of the first big lawsuits that I covered, and it started with, "This is a lawsuit because of the defendant's greed." It had all the tea in the lawsuit. So we started covering that lawsuit, and then Tati Westbrook sued a YouTuber. Those two lawsuits, to me, seemed to be linked. Some of the allegations overlapped. That YouTuber at some point said, "Hey, my source for this shit was Swanson," as we know, because it was later in other lawsuits. So that case had gotten dismissed on a motion to dismiss for jurisdiction and did not get refiled. They reached a settlement agreement because of the, "Hey, this is what the business partner told me." The business partner litigation needs a roadmap. I need to make a mind map of this shit. Originally filed in California. California said, "Hey, this is Nevada corporations and a Nevada individual and the Westbrooks who want to be in Nevada. The form is not proper here in California. Go to Nevada." So Swanson said, cool, and filed in Washington State. Washington State finally said, "Bruh, Nevada," but not before a ton of tea got spilled up in Washington in that litigation. And we have all of those on the channel as well. The playlist is long at this point. So that was up in Nevada. While that's pending in Nevada, we then see a lawsuit, multiple lawsuits, filed in Nevada. So pending in Washington, filed in Nevada by Halo Beauty, the Westbrooks, against Swanson. So we see the fallout from the YouTuber saying the things in this Nevada lawsuit. We covered it. It was full of information. It was like the business partner was spilling the business tea to get it out on the internet, and then it got out on the internet and did damage to the business. That is kind of the heart of that part of the Nevada lawsuits. Then Swanson sues the Westbrooks in Nevada. The Westbrooks personally sue Swanson in Nevada. And now there is a culmination of lawsuits in Nevada in the business court. So there is the heart of the lawsuit, Halo Beauty et al. Versus Swanson over business secrets and other things, essentially. Then you had the Westbrooks personally suing Swanson for the breach of privacy with regard to that recording. That just got dismissed. We're going to look at that too. And then we've got Swanson suing the Westbrooks in Nevada. We've got a motion for sanctions, motion for attorney's fees that was just granted. This case has just started growing. Oh man, oh man, oh man. It is. So everything is in Nevada. Now everything is in Nevada. Alrighty, let us get into all of that. So I'm going to kind of give the rundown of where we're at with the Nevada case. I kind of think I just did. I don't know if there's, well, let me just jump into the latest filings and then we will go from there. I think that's probably the easiest way to do it. With the motion to dismiss that was granted, the motion to dismiss was granted. The Westbrooks sued. I'm just going to pull up things so it's easier to show you. This is going to take me a minute. I can't keep all the tabs open and keep my computer running. So it's going to be bit by bit. So we're just going to have some patience because it's so many cases. But y'all know what it is. Y'all know what it is. All right. The Westbrooks sued Swanson personally. This is the one that just got dismissed. So I'm going to show you that as we take a look at it. This is going to come up in the other lawsuit. They are connected for sure. This is over the recording that we've talked about that happened, a number of years back. It's going to be in the facts here. So this is the Westbrooks personally versus Swanson personally in Nevada. November 2020, Swanson called a childhood friend of Miss Westbrook, talked about, threatened, all the same thing. All the same things. Illegal recording, blah, blah, blah. The causes of action in this are invasion of privacy under California Penal Code. But as the motion to dismiss pointed out, I don't know why this page isn't loading. And as the court determined, the statute of limitations for that cause of action is a year, and that statute of limitations has run. Whether or not we will see a motion to reconsider, I don't know, but we could. So that got that part of these fleet of lawsuits, this bouquet of lawsuits has been dismissed at this point. That was kind of the most recent one. I think part of the reason that this suit was filed strategically was not just to bring attention to the court that there was some potential issue with this recording, but so you can literally deal with it and they wanted declaratory relief. So the judge to say, yes, this is an invasion of privacy. You can't use this audio recording. It's going to continue to come up in the other lawsuits because Swanson keeps leaning in to the audio recording saying, look, this recording proves my point. And the Westbrooks are saying, A, it was illegally recorded, and B, no, it doesn't. So that's what that was. Let's get to back up. We gotta back up to the motion for sanctions and the motions for attorney's fees in the Halo Beauty versus Swanson case. And then we will get into Swanson suing the Westbrooks. I think that's the most organized way to do it. I think so. And we're going to just do it that way. Okay, we're just going to jump into this motion for attorney's fees real quick because we know that this was granted, but we're going to give the basis because it's easy to do. This is all of the lawyers. Here we go. Let's just pull it up. So this is the Nevada attorneys plus Salty and Queen Levine, who, yes, we had a nice time in Vegas. We talked about this briefly in Vegas, but not a lot. I'm like, we're out drinking. I'll read the motions later. I know it's happened. I saw it on Twitter. Motions for attorney's fees and costs. This is from July 13th, 2022. Since like the end of May, we have not been able to cover much other than other. And this has all of the suits. So when you look at this header, it's got all the associated suits. Halo Beauty Partners versus Swanson. Halo Beauty Inc. versus Swanson. Swanson versus Halo on the cross complaint. And then there's more. Introduction. On June 29th, 2022, this court entered an order granting in part, denying in part the Halo entity's motion for sanctions. In the order, this court awarded the Halo entities the reasonable attorney's fees and costs associated with opposing the motion to dismiss for the form non-convenience. Here's the thing. Remember when I said that they filed it in California? And then California was like, bruh, nah. It needs to go to Washington, or it needs to go to Nevada. And then Swanson filed it in Washington. Right. So the background is they filed it in California. Tati et al. filed a motion in California for forum nonconvenience. The court granted it. Swanson had already filed in Washington, even though the forum nonconvenience was pending in California, and the suit shortly thereafter got filed in Nevada. And in Nevada, you know, Tati et al. Was like, this is where the suit should come. And they're like, we're pausing it. The suit got paused in Nevada till the California court decided what they were going to do. But then Swanson brought a forum nonconvenience in Nevada, even though the California court had said Nevada's the right place. So this is all stemming from Swanson's attorneys being like, hey, we don't want to be here in Nevada. This isn't the proper place. Mind you, these are Nevada companies and Swanson's a Nevada resident. So when we're dealing with Nevada companies, the law is going to apply to the companies from Nevada. So the California courts are like, I don't give a fuck. Bye. Go to Nevada. Your Nevada companies, you're governed by Nevada law. Nevada cares. We don't care. She doesn't go here. And that's exactly what Washington said. She doesn't go here. But while that was pending in Washington, Clark tried to get the case yeeted out of Nevada. Well, if he had gotten it yeeted out of Nevada, then there would be no forum for it because nobody else would have jurisdiction. So mess. It was a mess. And with that, there are ways to just keep spending money in litigation. Hence the motion for sanctions, because this is your fuck around and find out. It's like, what are you even doing though? California said, go there, just go there. Go to your home. What are you doing? So Swanson had filed a motion to dismiss for forum nonconvenience in Nevada based on the fact that defendants Clark Swanson and Swanson Global Enterprises needlessly multiplied the proceedings to increase costs unreasonably and vexatiously. The HALO entities filed this motion identifying the attorney's fees and costs incurred in opposing the motions. As shown below, the HALO entities' attorney's fees were reasonably incurred based on the analysis of Brunzell factors, and that's the case in Nevada that's going to determine this. Now, the interesting thing is that Swanson actually later withdrew the motion, but not after this, not after legal fees were incurred. It's just, I saw a question that was great and I'm trying to grab it. Hold on, give me 1 second. Because I saw it and I was like, that's a good question. Somebody was asking what laws in Nevada Swanson was trying to avoid. I don't know if he's trying to avoid a particular ruling in Nevada or, there we go, Joe Jersey. I'm going to save that for questions. It's a great question. I don't know if he's trying to avoid a certain law in Nevada. It's possible. Or if he's just trying to literally say, chase me. Because this is costing everybody so much money. And the point of this litigation, I don't see how Clark wins any of this stuff yet. I have not seen yet how he comes out on top of any of this. But when people are locked at horns in litigation, it sometimes doesn't matter. And what we saw with Amber Heard, and I don't know if we'll see this in this case, but what I think we saw with Amber Heard too, is you will start seeing litigants who just want to continue to litigate. And a lot of attorneys will say, no, we're not doing this. And then you'll start seeing attorneys turn over. And that's when you're like, ooh, you're just now shopping for the attorney that will just be like, yeah, we'll keep filing shit. Because a lot of attorneys are like, no, we're not wasting our time. This is dumb. We're not doing this. All right. So they're going to go through the legal standard. We're going to go through the discussion. The HALO entities employed the law firms of, this does not say Stacks. My brain's salty ass. BHFS, sounds like a high school, and Salts et al. Sorry, Jason and Salts et al. I haven't met the other partners, so when their names are at the end, they just get sorry. We're just going to go with the first two. Anyway, so Jacobson's also like, we don't know her. Sorry, we haven't met the whole firm yet. We don't know. But anyway, Salts et al. To represent them in the underlying lawsuit in opposing the motion to dismiss. The high school and Salts et al. Expended time and effort reviewing the motion to dismiss, strategizing, researching, of course, because you have to. Because you have to. The thing that Amber Heard said that was correct on the stand was, I got sued. I didn't really have a choice. Correct. Accurate. They didn't have a choice. He did this. He made the motions. They have to deal with it. They absolutely have to deal with it. So correct. Drafting the opposition, coordinating for the hearing, and which ultimately never occurred. Based on these efforts, the Halo entities incurred $28,890 in attorney's fees and $779 in costs. Not an unreasonable amount of money for the work that went in. It's just not an unreasonable amount of money. And then they go through the lawyers, why the lawyers bill at the rates that they bill at, who bills at the rates that they bill at. What we saw this again when we went through the attorney's fee motion in the anti-slap for Ethan Klein and stuff. We've gone through these, but they list out their qualifications, how long they've been practicing, where they went to school, why they bill the hourly rate that they bill, et cetera, et cetera. So we will continue. The character of the work and work actually performed. Hey, we had to prepare for this motion, the result of the work. While the Swanson entities withdrew their motion to dismiss prior to the hearing, the Halo entities' opposition was well drafted and supported. They would have been successful in their opposition, as indicated by the Swanson entities' withdrawal of the motion to dismiss. They withdrew it, and sanctions were still granted, and attorney's fees were still granted. You let me know if you've seen it. I haven't. Because ultimately it was dismissed. A lot of courts wouldn't go ahead and give attorney's fees. But I think it makes sense in this context that the court's like, with all of the context, like, no, what we're not going to do is make motions for form nonconvenience everywhere, especially in the form that is legitimately the one that is the proper form. Form being where the case should be. All right, so let's go to the court's ruling real quick. And which is, there are so many, which is just the minute order at this point. And take a look at that. I know Salt's tweeted about this. I got tagged in it a whole bunch because you guys wanted to hear what was going on. And then there's some discovery stuff going on that we're going to get into. August 31st, 2022. All right, before the long weekend, go for it. All the people that are present, Swanson, attorneys, also present, James and Tati Westbrook, representatives for plaintiffs, present via the video conferencing app. Arguments by plaintiffs' attorneys, those are defense attorneys. Regarding the merits of the opposition to the motion, the court stated its findings and ordered plaintiff's motion for attorney's fees and costs granted for all amounts. So granted in full. Mr. Fretz to prepare the order and submit it to opposing counsel for approval. So the order will be coming. It's just not done yet. But this is, plaintiff's attorneys, sorry. Maximilian is Tati's attorney. My brain is tired. Shapiro is Swanson's attorney. And by Tati, it's Tati and Halo and James. It's all together. So the court is like, no, you can argue it, but no. And yes, Swanson's attorneys did argue that attorney's fees shouldn't be granted. They argued that they withdrew the motion. The court was like, this is not what we're doing at all. All right, we're going to move on. There are additional motions that we need to cover. If I could see my screen. Fred, you're blocking the screen, my dude. My cat's like, I don't care if I'm blocking your screen. What? We don't care. Let's see. We're going to go through a brief motion to compel because there is a lot going on. There's a lot going on in this litigation. When we look at business litigation, if you are a creator in any way, YouTube is a business. You need to set it up like a business. This type of business litigation is so intense. It is so all-encompassing. I imagine that this is just exhausting and stressful for all parties. Let us move on. So this is the motion to compel. I think it's Francesca. Von Fisher to produce documents and motion for clarification regarding representation. So this is a first look. We're going to look at it real quick. This is from August 17th. I have not checked in really with this particular case since the end of May, really. So we do have some catching up to do, but this kind of catches us up. This is the proper form. All the other cases are going to end up here, which is why we're seeing Swanson. I think why we're seeing Swanson sue the Westbrooks here. We're going to go look at that next. So we're going to end up with everything. When did I say this? 8 months ago, a year ago, when I said all these cases are just going to end up in Nevada. 8 months later, and a ton of money for everybody involved, we're now just going to see all these cases end up in Nevada. That's just what's happening. Alrighty, memorandum of points and authorities. Always makes me think of Lincoln Park, but anyway. Months ago, the Halo entities, I just say Tati, but the Halo entities served Ms. Fisher, I think it's Francesca. I might be saying that wrong. Von Fisher. We're good to go with Miss Von Fisher with a subpoena ducis tecum, an SDT, if you will. It's hard to say the proper way, but the subpoena. To date, Ms. Fisher has produced no responsive documents at all, and now we're into the discovery fight. If we've learned anything, I hope as a collective law nerd group from the Depp versus Heard case, it is how much fighting can happen over discovery, especially when we finally got to all of the unsealed documents. You see all of these fights over discovery, and we are starting to see that in this case because this is exactly what's happening. Y'all are on Fred's side. Fred be Fred, and he does. He absolutely does. He wraps himself. So I have like shears on the window, and Fred like burritos himself into the window shears like a hammock and then like leans up against it. It's just hilarious. But then it blocks the screen. He just, and George is back there too. George does not block the desk nearly as much as Fred does. Fred's like, I don't care. We're on Fred time, baby. It's code Fred. All right. To date, Ms. Fisher has produced no responsive documents. Instead, she answered each of the requests for production within the subpoena as follows. None at this time. Reserves the right to supplement the response to this request if additional information becomes available. Fisher's proffered no details of her search for documents and has claimed no privileges, simply refused to produce the documents. A cursory review of defendants Swanson and Swanson Global's discovery disclosures confirmed that there must be documents within Ms. Fisher's possession, custody, or control. In fact, attached to this motion are emails to Ms. Fisher in which Swanson, Ms. Fisher's then cohabitant and now husband, directed her to assist in providing information in illegally adding her own parents to the payroll of the Halo entities. This is why discovery of Swanson's wife, now husband, Swanson's wife. So if you remember, for those of you that are new here, drop a 1 in the chat if this is your first Westbrook stream. So absolutely. Drop a 1 in the chat. Lady Chris, hello. I enjoyed being on your flight last night. You were delightful. Good to see you. If I didn't have to run for my connection, I really wanted to take a picture and I was so bummed I couldn't because my connection. It was a little, we had to get all the way back over across ATL. Everybody, the chat is like, this is our first Tati stream. Okay, let me, I don't know if I've rode so far well, but with regard to this bit of this case, it is alleged in this lawsuit that Tati Westbrook's business partner, Swanson, added his in-laws to the payroll of Halo Beauty and to the health insurance paid by Halo Beauty, even though they were not actual employees of Halo Beauty. This is now saying that his wife helped add her parents to the payroll of Halo Beauty. He was the one doing the books, so he would have been the one that had known this. He alleged in one of the responsive documents that it was with approval of James Westbrook. They've denied that, so here we are. They're saying the in-laws were improperly added to payroll and to health insurance. He's saying, I had the okay. And now they're trying to subpoena the wife for information, or subpoena documents for information. And they have seen that she's on these emails and she has failed to produce them. Well, if she's on the email, it's a problem. Lucinda says that seems rather embezzling. That was the allegation. That was the allegation. So there we go. So they're saying, look, we have the emails that she's on with Swanson. I can't wait to go look at the emails. Love it when an email's attached. Always give us exhibits and pictures. They are the best. So we will go see. But if she's on the emails, they're like, bruh, we know there's at least some responsive documents. You need to turn them over. And this is why they're going to the court saying there's at least some. Make them turn them over. All right. Let's see. This court should not stand idly by while Ms. Fisher openly and notoriously flouts her duties to search for and produce all responsive documents. Yeah. If there's not even been a search, there's going to be an order from the court saying you need to engage in discovery. Like, discovery is a very big part of all of this. All right. Separately, California attorney Sammy Zarek has independently and improperly stalled Miss Fisher's production of documents. How? Specifically, Fisher is a Nevada resident, lives with Swanson in Nevada, despite that fact that Miss Fisher is a Nevada resident responding to a Nevada. Look, Vegas has Vegased my brain. I apologize. To a Nevada subpoena issued in pending Nevada legal proceedings. Stop saying Nevada. It's so much. By the time we get to nutraceutical, my brain will have stopped working completely. Despite the fact that Fisher is a resident of the state, the subpoenas issued in the state, the legal proceedings are in the state. Approximately 2 weeks prior, Mr. Zarek being admitted pro hoc vice by this court to represent only the Swanson parties in the Nevada in this litigation, he issued Miss Fisher's response to the subpoena. You can't do that. Signing the responses on her behalf and putting the responses on his own pleading paper. Here's the problem here. Just the lawyers in the room are like, the non-lawyers in the room are like, wait, does that matter? Yes. Here's what is said. This attorney is admitted by the court pro hoc vice. We talk about this all the time. You know, Camille Vasquez is a California attorney licensed in California. Despite what some on the internet might believe, being licensed in one state doesn't mean you can't ever go into court in another state. You can. You just have to follow the proper procedure. And if you've been practicing for a while and have not had issues with the state bar, it is not very hard to get admitted pro hoc vice in another state to appear. It's what Saltz and Lonnie are doing in Nevada. There's a Nevada law firm, and then there's the California law firm that's kind of, it seems to me, overseeing all of the other things because they have been kind of the quarterback running the plays on all the litigation across 3 different states. It's not hard, but you can only do what you are admitted pro hoc vice to do. And so they're saying, look, you're admitted pro hoc vice to represent the Swanson parties in the litigation in the court, but a third party subpoena to not one of the parties is beyond the bounds of what you can respond to. So that's what's going on with this, which is why even though it feels like a small thing, it is not a small thing. The attorney who is representing Swanson and the entities can't also, without being admitted further pro hoc vice, start responding to these subpoenas. That's not a great idea. She is going to need to get a lawyer, or the attorney is going to have to extend their pro hoc vice, because that's not what it is. And there might be a conflict there between her. Well, that's getting into other issues. We'll get sidetracked and never get back. At this time, Mr. Zarek is only licensed to practice law in California, has taken no steps to legally be able to represent anyone else in the state of Nevada for any reason, especially non-party witnesses who reside in Nevada. As such, the assistance with the responses on Swanson's wife's behalf is completely inappropriate and likely to constitute the unauthorized practice of law. They're just throwing it out there. They're like, dude, continue to fuck around and find out. This litigation is going to go on forever. That's not what I wanted to do. I wanted to do that. Nevertheless, seeking to move this issue along, but without waiver of objection, the Halo entities informed Mr. Zarek that his responses were inappropriate and asked to be directed to Fisher's Nevada counsel so they could meet and confer. Zarek has refused to do so, arguing that this court's later order admitting the pro hoc vice to represent the Swanson parties allows him to represent Ms. Fisher, who is not a party to this action. I think the court's going to agree with Tati's attorney on that. When that excuse failed, or maybe they already have. When that excuse failed, Zarek then insisted that his responses on behalf of Ms. Fisher and his meeting and conferring with the undersigned was not practicing law. Responding to a subpoena on behalf of a party, I think is going to qualify as practicing law if you're holding yourself out as a lawyer, responding to a subpoena for a third party. If I responded to a subpoena on my own behalf, even though I am an attorney, but did that as a civilian in a state where I don't practice, probably wouldn't be practicing law because I'm answering it for myself. But if I'm answering one for someone else, I think the judge is going to think that's practicing law. I don't think this is a great argument. The Halo entities disagree, and the undersigned does not want a violation of Nevada Rules of Professional Conduct 5.5a. Given this disagreement, the Halo entities come before the court seeking clarification. Your Honor, Kath, wait, I'm lost. Who's Miss Fisher? Swanson's wife. Your Honor, look, there are things that are not practicing law in the law adjacent spaces, but responding to legal pleadings, responding to subpoenas, those are law things. Okay. So, let us continue. Relevant factual background. The court's going to be like, what? This is the court. This is the court. The court is going to be addressing this after they've already granted sanctions on a withdrawal motion. Let's talk about how thrilled the court's going to be with Swanson and his legal team. Let's talk about it. Let's talk about it. Because they're like, what are we doing? Stop it. All right, let's get into this background as best we can. This will give all of you that are new here, not new here, but new to this particular fleet of litigation, a little bit of a background, or at least a background into this. The Halo entity sought relevant discovery from Swanson's wife related to Swanson's hiring of his in-laws. On April 8th, 2022, the Halo entities served the Swanson parties with a notice of intent to serve an SDT on Francisca Von Miss Fisher. No, the Miss should probably not be there. Francisca Von Fisher. Miss Swanson. The Swanson parties lodged no objection to the service of the subpoena to the non-party witness. On April 20, 2022, the Halo entity served the subpoena on Swanson's wife. On May 3rd, 2022, California attorney Zarek emailed the response to the subpoena utilizing his own pleading paper and signing the responses on behalf of Ms. Fisher. This is why it matters, because that's a legal response. In response to the subpoena, Fisher, through Zarek, provided no responsive documents. Instead, responded to each of the requests as follows. None at this time. Fisher reserves the right to supplement the responses to this request if additional information becomes available. That's not going to fly. Ms. Fisher gave no indication as to whether she did any search for responsive documents or otherwise made any good faith effort to find the documents. The Halo entities reviewed the Swanson parties' disclosures and uncovered documents showing without a doubt that Fisher does indeed have responsive documents in her possession or control, or at the very least could have obtained through the process of a reasonable inquiry of members of her own household. Specifically, the Swanson parties disclosed emails that included Ms. Fisher and involved Ms. Fisher's assisting Mr. Swanson in the Halo business, including the unlawful hiring of her parents. Not only does Fisher's email address appear on the email, but Swanson clearly directs Halo Beauty's payroll processor to coordinate with her in order to onboard her parents with the company during the time period that Swanson and Fisher were not married. So that answers that question. I saw a lot of you in the chat going, wait, at what times were they married? Hey, Amy, I have 2 more employees I would like to add. I've copied Ms. Fisher on this email. She will help coordinate with you. They will each be full-time at $8.50 an hour. Jason, please coordinate with Fran for benefits as discussed. Halo will pay their full benefits. Best regards, Clark. I can't wait to get to the emails at the end. We're going to just keep going. Because I want to get to the end. As such, it's indisputable that Ms. Fisher has documents responsive to the subject subpoena within her possession, custody, and her control, and has intentionally refused to identify or produce them, despite the fact that Ms. Fisher and the Swanson party's shared attorney has direct knowledge of and has previously disclosed the existence of such documents. So they're like, not only are there documents that we've seen, but you have to know there's documents that we've seen because you gave them to us. Why, yes, Mr. Swanson and Mrs. Swanson, you gave us these documents. Both parties have them. Oh, yoy. We need more lip gloss for this. The rest of my lip gloss is in my purse, like all the way across the house, because I forgot to pull it into my office, because normally it lives in my office. Oh, boy. The Halo entities attempted to meet and confer with Fisher's Nevada counsel, but to no avail. Mr. Zerg is a California attorney who is not licensed to practice in the state of Nevada. This has been made abundantly clear. Thank you. About 2 weeks after Attorney Sammy sent the Halo entities counsel Swanson's wife's responses, quote unquote, to the subpoena, this court entered an order granting the Swanson party's motion to associate counsel, admitting Sammy to represent the Swanson parties in this action only, because that's what you do on a pro hoc VJ. Nothing in the order granting the motion to associate counsel indicates that Mr. Zarek has been admitted to represent non-parties to the action. On June 14th, the Halo entities, through undersigned counsel, sent a letter seeking to meet and confer with Ms. Fisher's Nevada counsel regarding her deficient responses. On June 27th, Zarek and the undersigned conferred regarding the deficient discovery responses, and the undersigned expressed the need to meet and confer with Nevada counsel. During this call, the undersigned explained the Halo entity's position that the Nevada rules of professional conduct prohibited the attorney from representing Fisher, a non-party. On June 28th, he responded that these positions via email, arguing that 1, his helping Ms. Fisher respond to a subpoena was not practicing law because she could have responded to the subpoena on her own, but didn't. That's the difference. 2, his actions fell within exceptions to the unauthorized practice of law under the rules of professional conduct. Oh, there's emails. On July 10th, the undersigned responded, 1, that assisting in responding to the subpoena was in fact the practice of law. I think so too. 2, the exceptions that Zarek cited to did not apply because A, was not admitted pro hoc vice to represent Ms. Fisher. You would have to be representing that party. And B, there was no California action incidental to the subpoena. Right, because there aren't any more California actions at all. On July 13th, 2022, counsel responded, quote, I cannot change history. Fair. That's fair. That's accurate. I cannot change history, but I would much rather move this issue along. Oh no, no one's letting this go, my guy. This is not getting let go. I cannot change history, but I would much rather move this issue along. Otherwise, what would you suggest that I do? I wonder if there was conversation about what they would like to respond in email versus what they did respond in email. What would you like that I do? I would suggest my snarky response. I would suggest that you provide us the information of Nevada counsel and stop flouting the Nevada rules of professional conduct, which you've said that you would abide by when you were admitted pro hoc vice. This could actually get the court to yeet this attorney from representing pro hoc vice because the attorney's already exceeded the bounds of pro hoc vice. That could happen. Oh, that would probably piss people off quite a lot. Could you imagine if the court's like, oh, fuck find out. I'm going to say that a lot today. I have a feeling. Now you don't represent anyone. All of your clients need, or not, well, yeah, all of your clients need Nevada counsel. You are no longer represented. You are no longer representing anyone pro hoc vice. The court can revoke that status. On July 14th, 2022, the undersigned responded that attorney should direct the Halo entities to Nevada counsel for a meet and confer, and that the Halo entities had exhausted their efforts due to this impasse. As a result, the Halo entities made a good faith effort to meet and confer. Argument, as shown above, two problems are plaguing the production of documents. First, Mrs. Clark Swanson has completely failed to produce any documents that she has been commanded to produce through the subpoena. Again, a subpoena is using the power of the court. The power of the court to compel you. The power of the court compels you to give the documents. This is a court order, so you have to comply with said court order. This court should compel her to produce the documents requested in the subpoena. Second, attorney is halting the discovery process by insisting that he is properly representing a third party Nevada resident responding to the subpoena. Well, he has been admitted to represent only the Swanson parties. Ms. Fisher should be compelled to produce the documents responsive to the subpoena. Let's see. The Halo entities respectfully seek clarification. I'm going to finish the sentence, I swear. The Halo entities respectfully seek clarification as to whether Ms. Zarek may represent Ms. Fisher related to the subpoena. Your Honor. Excuse me, Your Honor. We're telling. This is can Your Honor, can they do that? It's just telling on someone. But not in a like, hey, we're tattling on you, like an excuse me, could you just clarify, are they allowed to do that? Because I didn't think they were allowed to do that. Is that just cool? Because it seems like nah. So, Your Honor, I just want to bring it to your attention. Could you clarify for me? And then the judge is going to be like, I'm sorry. What the fuck? Oh, that'll be an interesting hearing. This judge is going to be thrilled. Thrilled. The Halo entities respectfully request that this court clarify the extent to which its order granting the pro hoc vice admission applies to this dispute. They know the answer. They've just brought it. It is now well brought to the court's attention. Well brought to the court's attention. Attorney argues that the undersigned counsel should meet and confer with him. Attorney asserts that his representation is not the unauthorized practice of law. They are asking the court to tell this attorney, is this the unauthorized practice of law? Because he has admitted pro hoc vice in this action. While it is true that the court admitted him, this is the same argument we looked at. It's only the Swanson parties, not a third party. I think there's also probably some conflict stuff. Oh, they're going to keep going. Excuse me, Your Honor. You should probably revoke the pro hoc vice status. They're not going to say that. But wait a second. Dave Matthews Band announces 11-show fall tour beginning in Vancouver on November 2nd and ending with a 2-night stand at MSG 11, 18, and 19 warehouse ticket request now open. What? You can't do this to me. I'm in the middle of a live stream. Ticket requests. I'm going to have to text my friends. I'm sorry. Just... Y'all, just give me 1 second. Which shows are we going to? My text all just blew up. This literally happened, let's see, like 5 minutes ago. Sorry. Anyway, Dave fans, the fall tour has been announced. All right. Damn it. I need to know. All right. We're back. We're going to finish this. I'll go look at tour dates in a minute. The request period will probably be through the end of the day. Don't you worry. Fall show. Look, he introduced, okay, just as an aside, sidebar. We're taking a sidebar. I didn't go to the Gorge this year. I wasn't going to go to the Gorge this year. The Gorge can be a lot of work. Last year, the Gorge was very COVID-y. I couldn't this year. They played 6 songs that they have not played the entire tour, including one of my favorites, Drunken Soldier. I was like, what is happening? So the attorneys, they got me this time, but it is going to be a fight because this particular conference that I really enjoyed is always Labor Day weekend. You know what else is always Labor Day weekend? Labor Day. Labor Day at the Gorge. The Gorge is amazing. Oh, I'm sure the notification came out. I have not been on my thing. It was the DMB hub alert that got me on my watch because normally I turn things off. It's okay. It's pre-order for the warehouse. I'll go take a look at it after the stream. They're not on sale yet. But anyway, so the Gorge had some of the most fucking amazing set lists. And I saw Dave at the beginning of the tour. He wasn't playing Fool in the Rain yet, which is now being played live. And I have one more opportunity, but a fall tour. Do you know why I love a fall tour? Because it is so fucking hot on the summer tour. It is so hot. We did the pit in the Gorge. It is so hot. It is so fucking hot. You know what else is going to be hot? Arizona. Arizona is going to be real fucking hot. You know what I love about a fall tour? It's not so damn hot. I love a fall tour. My favorite show I think that I've ever seen. No, there was a backstage experience at Dodger Stadium. I loved that. There used to be 3-night stands at the Velodrome that got renamed like 700 times. I think it's Home Depot Center now. It's probably something else. StubHub, I don't know. In LA, loved seeing him in Irvine. But my favorite show was literally the show before the world ended on February, was it 28th? It was the Leap Day show in Vegas, 2022. Or 2020. It was the most amazing show. And I didn't get tickets for Dave and Tim in the Riviera this year yet. So fall tour. It's fall tour. Anyway. All right. I'm sorry, Squirrel. This is why I turn off all of my alerts while I'm streaming, so you guys don't have to live through my stream of consciousness. We need to finish up with Tati. Let's swoop back. God, I love a fall tour. It's been a while since I've done a fall tour in the States. I'm so excited. Okay, sorry. Fall tour. My brain. Today has too much excitement. All right, let us get back to fuck around and find out. The court's not going to love this at all. Further, attorney's argument that he was not practicing law by advising a witness on how to answer a subpoena and assisting in responding to the same is rebutted by clear Nevada case law. Of course it is. The chat's like, bro, no. The non-lawyer chat are like, it feels like that's the kind of thing you call a lawyer for, and then a lawyer tells you, and then they answered. Of course, there is clear case law. The Nevada Supreme Court explained that when one relies upon the judgment of others as to his legal rights and receives advice or judgment, that is professionally given by one not a party to the transaction and not an attorney, a problem in unauthorized practice is presented, despite the attorney's assertion that, quote, all I was doing was assisting her in responding to a subpoena, which does not require a law license, but could have been done by her herself. Yes, she could have done it. But didn't. And he responded on his subpoena. His assistance in helping Ms. Fisher respond to the legal document is by definition the practice of law. And then they're going to get into it more and remind the court why this person should be heeded. They're looking for clarification, but it is a problem. Attorney's argument that his response was incidental to his representation of Fisher in California and was therefore expected. There's no California case Crucial to this exception is the requirement that the lawyer is acting with respect to a matter that is incident to work being performed in a jurisdiction in which the lawyer is admitted. There's no California case. Put differently, the subpoena would have to be incidental to a California case in which the wife is represented or the attorney is representing the wife. Conclusion, accordingly, the HALO entities respectfully request that the court enter an order compelling to produce and clarify whether this attorney may represent her related to the subpoena. This might end up with the attorney being yeeted from their pro hoc vice status. That is a possibility, or at least a strong admonition. Possibly more strong. Oh boy. The judge is going to be like, God damn it. What kind of a pile of shit have I stepped into with these parties? We've already got sanctions and attorney's fees over this form non-convenience. Now this, great. Now this. Oh, here's the backup. The attorney, this attorney subbed in not that long ago, and the other attorneys left. And the other attorneys left. So this, I think, let me go pull that document. I think this is the only attorney on record now for Swanson, which means if this attorney gets yeeted, let me go check. If this attorney gets yeeted, that is a big problem for Swanson, because then Swanson's going to have to find new counsel. And it's always expensive finding new counsel in the middle of this stuff. All right, let me, there are so many files. Let me find, I saw that motion for substitution of counsel a while back. Let's see. Yeah, here's the notice of withdrawal of counsel. So let's pull this up real quick and take a look. This is from June 10th. And this is the California attorney admitted pro hoc vice. This is the Nevada attorneys. So let's see who's yeeting. Kemp Jones LLP files a notice to withdraw. So let's see. It's only the Kemp Jones attorneys. No parties will be prejudiced by the withdrawal of Kemp Jones, as defendants will continue to be represented by James Shapiro of Smith Shapiro, PLLC, and the California attorney, Sammy Zrek. All right. So the Shapiro counsel has stayed on. This counsel is gone. And then the California attorney. Why not just have the Nevada attorney deal with it? Like, I don't understand. The chat is saying Wood Daddy Stack. Hello, Wood Daddy. Good to see you. Wait, Rob. Responding to a subpoena with literally responding to a subpoena on letterhead and advising a witness as to how to respond a subpoena. Do you consider that practicing law? What do you think? You're coming in at the end, so you're a little bit at a disadvantage, but that's part of the conversation going on. And we've already squirreled. We can't squirrel anymore. All right, Exhibit 1, notice of intent to serve the subpoena. Great. Here's the subpoena. Ooh, let's see what's in the subpoena. This is a subpoena for documents. Your attendance is required to produce and permit inspection and copying of designated documents, electronically stored information, tangible things in your possession, custody and control specifically identified as Exhibit A. Exhibit A. Let's see. I'm sure Rob's going to respond. Oh, and then I'm still talking. Miguelina, if you see Rob's response, will you just flag it for me? Because I might not. You didn't have to super chat your response, but I see a super chat from Rob, so we're going to go in and say hello real quick. Anyway, ADHD thought map, lawsuit squirrel, concert squirrel, travel squirrel, lawsuit. Y'all, side note, I saw a funny video. I'm building a squirrel catapult, and that's where my brain went. Don't catapult the squirrels. I would make them a little maze with like a food run. Anyway, that's what happened. And then we need to know if it's like, yes, the witness comes to you for your expertise. They rely on legal advice on the merits of the subpoena and filtering responsive documents. My view, it's the practice of law. See, I agree with you. I think so too. And I think once you put it on letterhead, there's no way to argue that it's not. But anyway, Exhibit A, definitions. California lawsuit is the Swanson Halo one. Communication. These are just the definitions, by the way, so everybody knows what we're talking about. Let's see what they're seeking. Nevada lawsuits. They identified which lawsuits. They identified the Washington lawsuit. Instructions, please see Exhibit B. All right. Documents to be produced. Communications, including but not limited to emails and text messages within the control, I would imagine, during the time period related to. Where is the time period? It's probably above, and I swooped past it. Halo. Edith Fisher being employed by Halo. I imagine these are the parents. Heinz Fisher being employed by Halo. Work performed. Health insurance. So this is all the parents being put on to the books. Any conversations with regard to Tati Westbrook, James Westbrook. Could they object that some of these are broad? Maybe. But you need a lawyer to go through this and have a conversation about it. Communications, including but not limited to emails and text messages with Heinz Fisher during this time period. Oh, so these are the texts with the mom. These are the texts with the dad regarding all of these things. Communications and emails with Clark during this specific time period with regard to all of these things. And you could make some, you can absolutely make some arguments about broad, about relevance. Like there's room to have a conversation, but this is why you have to talk to a lawyer to give legal advice about what you have to respond to, what you don't have to respond to, what exists, what objections you can make. Clark Swanson's communication with any blogger, vlogger, or internet commentator, including but not limited to content creators on youtube.com, twitch.com, and Instagram, related to Tati Westbrook. Clark Swanson's communications with any blogger, vlogger, or internet commentator, including but not limited to content creators on YouTube, Twitch, related to James Westbrook. Clark Swanson's communications with any blogger, vlogger, or internet commentator, including but not limited to content creators on YouTube, related to Halo. Swanson's communications with, internet journalists related to the California lawsuit, communications related to the Nevada lawsuit, communications related to the Washington lawsuit, communications not limited to emails with Clark from September 5th, 2020 to present related to Halo Beauty, the parents, Tati, James, lawsuits. And then back to the Swanson's communications with anyone related to Tati, James, Halo, the lawsuits during that time period, communications with any parties other than the parents. This is a very thorough request for documents. Your communications with any blogger, vlogger, or internet commentator related, but not limited to content creators on YouTube or Twitch or Instagram related to Tati Westbrook, James Westbrook, Halo Beauty, lawsuits. Any other documents not provided in response to the above with regard to Halo Beauty, parents working for Halo Beauty, lawsuits. Where are the emails? I want emails. All right, this was served. Responses. Preliminary statements. All right, Rob, this is the response that the attorney said is not legal work. This is the response. The attorney said this is not practicing law in Nevada. This is responding to a Nevada subpoena by a Nevada resident in a Nevada lawsuit by a California attorney saying that this is covered by their pro hoc vice admission with regard to other parties, but not with regard to this. The sky just got weird, but not with regard to this particular third-party witness. Hold on. Y'all, I'm sorry. The sky is crazy. We're going to take a picture for later because it is. What is happening? Hi, Middle Tennessee. I'm trying to focus. All right. The sky's like doom. That's what's happening out there. Today's a particularly ADHD day. Thank you all for sticking with me. Let's continue with regard to this response that is allegedly not practicing law. On their letterhead, here's the response. Preliminary statement. These responses herein are provided solely for the purpose of this action. They are subject to all appropriate objections. Expect for facts explicitly admitted. No omission of any nature whatsoever is to be implied or inferred. This is all boilerplate stuff that an individual wouldn't know to put in here. Right? Allie said, so this is Tati's lawsuit against Swanson. This is a discovery dispute inside of Tati and Halo Beauty's lawsuit against Swanson. Don't worry. Don't worry. Swanson sued them. That's next. So preliminary statements incorporated, general objections. Here's the general objections. All of the general objections. And then responses too. And they went through each request for production. Response to this request, none at this time. Response, none at this time. This is a legal filing. I don't know how you say this is not practicing law. Every single answer is none at this time, by the way. And it's signed, you know. I don't know how that's going to go. All right. Ooh, emails. Look, these are public pleadings. I have not gone through and redacted out the emails. Don't email people. Though what I will say is when it comes to the attorneys, their emails are all public. So you can find them on all of their things. Just don't email the people involved in any of the shit that I talk about, please. Thank you. All right. Clark Swanson to Amy and Fran. Hey, Amy, I have 2 more employees I would like to add. I've copied Fran on the email. She will help coordinate with you. They will each be full-time at $8.50 an hour. Jason, please coordinate with Fran for benefits as discussed. Halo will pay their full benefits. Hey, Fran, please fill out the attached employee packet so we may add you to payroll. This is all the payroll stuff. Let's see. What is this? Halo Beauty Partners letter regarding STT. Okay, so this is the, hey, we are in receipt. We are in receipt of the responses to the STT. We would like to meet and confer. Thus, please confirm that you are not admitted to represent this party, Pro Hoc Vice, and that your response to the subpoena, which were sent on her behalf, were not sent in association with Nevada Council. Please advise which Nevada Council we should directly meet and confer with. And then these are going to be the back and forth that we've already seen. What is this one? This is to Maximilian, which is Nevada Council for the Westbrooks. Did he write his bar number next to his signature? Probably. Hold on. So you're like, scroll back up, scroll back up. I mean, it's signed. It's got to be down there. Oh, no, I don't see the bar number down here. But it's up on, let's see. It's up in the heading, isn't it? Yeah, it's up in the heading. So the bar number is in the heading, not in the signature block. So, alrighty. Let's continue. There's an attachment. What was the attachment? The employee profile with direct deposit, fillable form. Direct deposit that as an employee that's not working. Dragonflies, I don't love $8.50 an hour, but you have to remember that these individuals did not in fact work for the company. They were put on payroll at full time and had 100% of their medical care covered, but it's alleged in these lawsuits that they never worked for the company at all. So they were not providing services. So they were getting, they were not performing any duties. They were getting 100% healthcare benefits. So Noelle's like, am I the only one who's like, you pay your parents $8.50 an hour, ungrateful? Well, Swanson, the Westbrooks allege that Swanson was not authorized to add his in-laws to payroll. They did not work. They received 100% medical care and pay, but did not work for the company. So there's that, if that makes sense. So let's see, maybe the 850 was to hopefully fly under the radar. I think that's probably more likely. Question, so is that insurance fraud? I would have to look again. I think it's as alleged. I think we're looking at embezzlement from the company. Is it defrauding the insurance company if it's being paid and they're not employed? I don't know. I would need to go look. So that. So health insurance is worth a lot more than $8.50 an hour. The health insurance, when we looked at this lawsuit the first time, the amount that was paid in health insurance was substantial. So we went through it. We went through the amount that was paid in healthcare. It was quite a lot. So now the chat is like, wait, that actually sounds like the best ever. Do nothing, get $8.50 an hour for 32 to 40 hours a week in full healthcare. Yes. So this is the problem here. So no, they were not working for the rate of $8.50 an hour. So this is what's alleged. Clark, again, alleged that James Westbrook gave him authority to put them on the Halo Beauty payroll. The Westbrooks have alleged that Clark did this on his own accord and they had no idea because he was the one handling everything. But those are in pleadings, God, probably almost a year ago at this point. So I realize we're filling everyone in as we go. So this is, again, Nevada counsel for the Westbrooks saying, yo, we're in receipt of your responses. However, we note that the responses were made on your law firm's pleading paper with no indication of associated Nevada counsel, which appears to be a violation of Nevada Rules of Professional Conduct 5.51. Footnote.
While your response indicates that there is a, quote, application pro hoc vice pending, I am aware of no case in which Ms. Von Fisher is a party and that you have applied to represent her pro hoc vice. To be clear, Ms. Von Fisher is not a party to the instant lawsuit, and therefore you are not admitted pro hoc vice to represent her.
And that's how they feel about that. Thus, please confirm that you are not admitted. The court is going to lose their mind. Once confirmed, please advise. This is not going to go over well. All right. From Maximilian to Sammy, we've just gone by first names now. Apologies on missing you yesterday. We too would much rather move the issue along. Oh, wait. Max, I just left you a voicemail. We can agree to disagree on this issue.
The court's not gonna agree to disagree.
We can agree to disagree on this issue. However, I am willing to meet and confer with you regarding the above referenced subpoena. No, they want to meet and confer with the counsel in Nevada who represents this individual. So if you would like to give me some dates to do so, that would be great. I cannot change history, but would much rather move the issue along. Otherwise, what would you suggest I do? I would suggest that you direct me to Nevada counsel. Sammy, they're very cordial in their emails. We haven't gotten to the snark ass emails yet. Yeah, these have not gotten nearly as snarky. Like the Britney Spears emails are like, the emails towards the end of Depp Heard are also, these are pleasant. These are still professionally pleasant emails. Apologies on missing you yesterday. We too would much rather move the issue along. However, we cannot engage with you on a meet and confer due to the rules of professional conduct, which specifics have been noted in one, my initial June 14th correspondence, and two, our telephone call on June 27th, and my email below. To your question, we have repeatedly stated, what would you prefer I do? We have repeatedly stated that you can advise us of the Nevada counsel we can engage with in a meet and confer. Duh. We believe that we have exhausted our efforts and plan to raise the issue and the deficient production with the court.
We're telling Mom we're done here. Bye.
That's how that went. And here are the rest of the emails below of them going back and forth over this issue. We're going to have to agree to disagree. I don't think so. We're going to ask the court for clarification because we're not engaging in this. Declaration of Maximilian. So Max is like, yeah, these are the emails I sent. This is the stuff that's in the pleading above. The emails are attached. Yada, yada. So where do we stand? Halo Beauty is still suing Clark Swanson. Halo Beauty has won a motion for sanctions on Swanson's withdrawn motion and is getting attorney's fees paid for upwards of $28,000. Swanson's California attorney might get yeeted from their pro hoc vice admission if the court's pissed enough. They're at least going to get admonished about it. Swanson's wife has not responded to the subpoena, and there is a fight over discovery happening. What else has happened? Well, Swanson sued the Westbrooks in, California, and then in Washington, and now in Nevada, and we haven't read that lawsuit yet. So we're going to go take a look at that, and God bless, hope that it's not too long, because then we want to get to some really, really snarky cease and desists. We're going to get out of the legal filings. We're going to get into the cease and desist in a minute, but let's take a look at Swanson. How many pages is this? 16? That's not bad. Let's take a look at Swanson suing the Westbrooks again in Nevada. If this lawsuit does not say this is a lawsuit because of the defendant's greed, I'm going to feel cheated. This is a first look. I have not read this one yet. This was filed July 29th. So this was filed just at the end of July. Interestingly enough, this is only filed by the Nevada attorney, Shapiro. This is not filed. The California attorney's name is not on this yet. I do not know if the Westbrooks have been served with this lawsuit. I do not know. This is the only thing on the docket so far. Because in the world of lawsuits, this is relatively new. All right, let's take a look at what's happening. I want to... amount in controversy and excess. This is just a jurisdictional number, exempt from arbitration complaint. Comes now plaintiff Swanson by and through attorneys suing James Westbrook, Tati Westbrook. General allegations. James and Tati Westbrook have their sights set on becoming YouTube famous.
They are YouTube famous. Well, Tati's YouTube famous. I don't know about James. What do you think? Chat, should we take a poll?
Is James Westbrook also YouTube famous? Do we need to take a poll? Let me know. James and Tati Westbrook had their sights set on becoming YouTube famous now, beginning in 2011, while profiting from relationships they had or were cultivating with other people, other influencers, I would think. Ms. Westbrook began befriending other YouTube celebrities in order to make money through cross-promotion of products. Poll. All right, let's put up a poll. Is James Westbrook YouTube famous? Look, and it's no shade if James Westbrook is not YouTube famous. He's Tati's husband. I think he's YouTube known, but I don't know if he's YouTube famous. Okay, Selena, you're asking the hard questions. How do you define YouTube famous? Fuck if I know. I don't know. We'll do that next. We'll do that next. So I don't know. I don't think her husband is YouTube famous, but we'll see. I want to see what you guys think. Maybe he's YouTube famous to you. It's speculative. What is YouTube famous? We need to ask Peter Mon. Has he defined it? I need to know. At least we get to talk about something a little bit lighter. YouTube is always fun. Miss Westbrook was also seeking relationships with brands to promote on her YouTube channel with which she could pair. What is this sentence? Miss Westbrook was also seeking relationships with brands to promote on her YouTube channel with which she could pair to put her name on the packaging. What is that sentence? Look, attorneys, Mr. Shapiro, I'm sure you're lovely, but attorneys, if you are talking about internet personalities, celebrities, or celebrities in general, write your complaints for those of us that will be covering them. Please, thank you. We want to understand the story you are telling, and you are making it hard. It sounds like she's trying to have sponsorships, but also wants to white label shit. It's all just kind of like, bleh. All right. In the fall of 2016, Mr. Westbrook saw a friend of his, Clark Swanson, beginning a supplement/vitamin line of products called Renuzin. Probably Renuzin. Is this the ED pills? Are we getting back to dicks? Are there dicks in this one too? I think these are the ED pills, but I'm not 100% sure. That's speculation on my part. Mr. Westbrook approached Mr. Swanson requesting that Mr. Westbrook and his then girlfriend They went and put her government name in there. Okay, I see you. I see you trying to dig at Tati Westbrook or dox her. Now wife, known as Tati Westbrook. Let's see. I got distracted. Mr. Westbrook approached Swanson requesting that Westbrook and his girlfriend, now wife, Tati Westbrook, partner with Swanson and make a supplement company and joint venture. Mr. Swanson had already developed numerous supplemental formulas for the launch of Renuzin and his own supplement company, named what? But agreed to hear out a pitch from the Westbrooks. Mr. Westbrook pitched heavily the idea of YouTube marketing, including cross-promotion,
which in the mid-20s worked so well. So many people, so much money.
Mr. Swanson originally set his terms at 60-40 ownership since he had the supplements developed. So interesting. He's saying that the supplements were already developed before they went to Halo, but that's not consistent of my understanding just from the other lawsuits. However, Mr. Westbrook continued negotiating for 50% of this and continued negotiating for 50% for Swanson and 25% for each Mr. and Mrs. Westbrook. On March 6, 2017, the business was ultimately organized as Inside Out Beauty Labs in the state of California, with Swanson owning 50% and Mr. Westbrook and Miss Westbrook owning 25% each of the business. While the business has undergone a number of different reorganizations, formation of different entities, all of these reorgs and formations have been undertaken with the single purpose of furthering the business. Without Swanson's formulas and research, the business would have no value. Well, okay. It wouldn't have those products, but all right. On or about July 17, 2017, the owners decided to rename the business to Halo Beauty Nutraceuticals, LLC, after months of development and work to secure packaging and distribution contracts by Mr. Swanson. On August 1st, 2017, the Westbrooks called Swanson in order to have an impromptu business meeting later that day. The Westbrooks knew their position in the business was only as the face and marketing of the brand because the Westbrooks had no way to develop the formula for supplements without knowledge of the business connections, knowledge and business connections of Swanson. So this is just the California lawsuit refiled. I mean, rewritten and refiled, but this is the California lawsuit. However, the Westbrook, they might have some we're going to have to look at statute of limitations because we're at July 29th, 2022 when this was filed. And a lot of this shit went down in 2017. I'm going to be interested to see what happens after this. Sorry, my brain just went, they were close in time when they filed it in California, and I don't know if I don't know if this will be stayed long enough. Anyway, there are some legal things I want to look at, but right now we're just looking at what they're alleging. It's basically a repackaging of the California suit so far. The Westbrooks pitched to Swanson on expanding the business brand into skincare and cosmetics because none of the skincare and cosmetic product lines were developed. The Westbrooks wanted ownership in the expanding business to be modified, with each of the Westbrooks and Swanson owning 33.33% of the business. With each of the Westbrooks and Mr. Swanson owning 33.33% of the business each. We don't need it twice. The parties discussed this expansion and the ownership interest for nearly 2 hours, with Mr. Swanson voicing his concerns of being relegated to a minority owner against two married and aligned people. The Westbrooks attempted to allay Swanson's fears by stating that no matter who makes the decisions, they will all reap the benefits of such a profitable business. The owners decided to rename the business just a few weeks earlier based on the expanded scope. Let's see. This turnabout regarding the name is just one of the many confirmations regarding the owner's agreement to expand the business's brand beyond just supplements. The business went on to launch 2 more supplement products with great success, with Mr. Swanson visiting skincare and cosmetics labs to develop. However, on or about April 6, 2019, the Westbrooks informed Swanson that they have been contacted by Seed Beauty for Miss Westbrook to have a personalized label through Seed. That became Tati Beauty, now closed, I believe, due to the ongoing lawsuits. The Westbrooks stated that they were going to partner with Seed to release Miss Westbrook's cosmetics and would no longer be working to launch products through the business. I think it was to not launch beauty. That's the heart of this dispute. The heart of this dispute is, was Halo intended to be an all-encompassing brand for Tati Westbrook's everything, or was Halo intended to be vitamins and stuff. And she was always intended to do other things to the side of Halo. That's the heart of this lawsuit, truly. Like, which verticals of YouTube business is going where? Swanson reminded the Westbrooks that the inducement for Swanson to transfer 16.67% of his shares to the Westbrook was the expansion of the business's product line to include skincare and cosmetics. Of course, we've already read the response from the Westbrooks in the other lawsuits, and that's not what they say. Swanson presented Mr. Westbrook the option of returning the ownership to its original configuration. I haven't heard that before. And no longer taking distributions as a 1/3 owner. I didn't know that they had done that. That's interesting. That's come up in none of the other lawsuits to my memory. Instead of readjusting the ownership, Mr. Westbrook instead told Swanson that the Westbrooks would continue cultivating the expanded product line discussed and agreed upon on August 1st within the business. Mr. Westbrook and Swanson agreed to continue to develop a skincare line, then develop and launch cosmetics. The Westbrooks took distributions on April 11th, 2019, each as 33% owners, 5 days after the discussion with Swanson about rebalancing the ownership interests. Over the course of the existence of the business, the Westbrooks undertook numerous actions and made numerous verbal statements, all leading Swanson to believe that the Westbrooks would continue to develop a subsequent product line of skincare and cosmetics, including making representations on application forms to different banks and other vendors. Well, if they have those, I'd be interested in seeing them. Making statements in different YouTube videos and to other people that the business was going to include skincare and cosmetics. There are different types of cosmetics, I will say. During the time, Swanson relied upon the Westbrooks' representations. Over time, relatives and childhood friends of the Westbrooks made their way onto the payroll, some over Swanson's objections. That's the first I've heard of that. That's the first time we're hearing of that. That's interesting. Partially as a result of Swanson's objections and after discussion between Mr. Swanson and Mr. Westbrook, the business hired the Fishers, Swanson's parents-in-law. Huh. Who else is on the payroll? Because Swanson's alleging that relatives and friends are on the payroll, but are they doing work? I have questions. Partially as a result of Swanson's objections and after discussions between Swanson and Westbrook, the business hired the in-laws. Ironically, Mr. Westbrook's only objection to hiring the in-laws was that they were not going to be paid as much as Mr. Westbrook felt they should be paid. I want to see where that's in writing. I have questions. No other objections to hiring the Fishers were asserted by the Westbrooks. Unfortunately, the Westbrooks ultimately refused to develop any further products, approve supplement and skincare products that were launch ready, or help Mr. Swanson operate the business in a meaningful way. Mr. Swanson, with the rest of the world, was informed through Miss Westbrook's YouTube channel that Tati Beauty is launching its first product. Why is this written in this tense? Hold on. Some of these sentences are killing me today. Mr. Swanson, with the rest of the world, was informed through Miss Westbrook's YouTube channel that Tati Beauty is launching its first product, a color eyeshadow palette. Was? Any and all further actions taken by Swanson to grow the business were met with disinterest, misdirection, silence, and sabotage. From October 25th, 2019 onward, the Westbrooks sabotaged the business by surreptitiously requested that vendors, suppliers, and contractors not speak with Swanson. Even worse, the Westbrooks, using their ill-gotten 66% ownership, hijacked the management and control of the business and did everything in their 2/3 ownership power to squeeze Swanson out of the business. Well, he's subsequently been fired from the business as well, which we saw in other legal pleadings. Okay, the Westbrooks further took punitive action against Swanson, firing the Fishers without any advance notice under the pretense that the Westbrooks were unaware that the Fishers worked for the business. Ultimately, the Westbrooks went even further by opposing the Fishers' unemployment claim. As a result of the strain and stress caused by the Westbrooks' inappropriate and extreme actions, Mr. Fisher's health declined and he ultimately suffered a fatal heart attack as a result of the stress, thereby imposing great emotional distress upon Mr. Swanson and his immediate family. Well, someone's passing is horribly unfortunate. Also new information in here. And they're tying it all back to the stress of this business. I think legally speaking, that might be difficult. The Westbrooks have also filed a lawsuit in their own name against Swanson, and even worse, and upon information and belief, the Westbrooks have and or hold on. The Westbrooks have also filed lawsuits in their own name against Swanson, and even worse, and upon information and belief, the Westbrooks have and or intend on causing the attorneys representing the Halo businesses to perform work on the Westbrooks' personal claims while billing the Halo business for that work, thereby forcing Swanson to pay a portion of the Westbrooks' personal legal fees in the Westbrooks' unfounded claims against Swanson. Some of the claims against Swanson have already been yeeted, though. Okay. First claim for relief, fraud in the inducement. And that's going to be I'm not going to go through each of these claims that way, but this is going to be you said it was going to be this way, and I only did it because you said it was going to be this way. And then it's not. This, by the way, would be a great breakup line. This is a perfect breakup line. You're with somebody who's amazing, and then things start to shift, and you're like, wait a second. This was fraud in the inducement. You used to do these things. These things are not done anymore. Fraud in the inducement. You induced me to want to be with you with all of the loveliness, and you have stopped courting. That was fraud in the inducement. That is the perfect context for that. All right. So I wouldn't have given up. And this is the claims we've seen over and over again from Swanson. I wouldn't have changed ownership of the company if you hadn't said that we were going to do this. The Westbrooks have a completely different side of this story. Second claim for relief, constructive fraud. Plaintiff repeats and alleges above. The Westbrooks have gained an unfair advantage over Swanson through unjust means, and the plaintiff is damaged by the conduct. As a direct result of Swanson's justifiable reliance, Swanson has been damaged in an excess of $15,000. These are statutory limits. Third claim, fraud. It sounds like same. When they induced him to give up part of the business, or when he alleges they induced him to give up part of the business. And again, the answer to this is going to be this maybe more scathing now that it's like the third time, because the Westbrooks have answered in California, the Westbrooks have answered in Washington, same claims as here. And every single time they're like, that's not how we see it. So let us, fraudulent misrepresentation, again, based on all the above, the Westbrooks made a false representation to Swanson. This is like all of Tati's verticals will be under Halo. That's what that's referring to. Negligent misrepresentation, negligence, gross negligence. That'll be interesting. I wonder exactly what. It's not. As a business partner, the Westbrooks owed a duty of care. Interesting. The Westbrooks' actions and or failure to act when they knew or had reason to know facts could lead a reasonable person to realize that their conduct not only created unreasonable but high probability that substantial harm would result. I wonder what exactly they're thinking with that one. Eighth claim for relief, conversion. You took my ownership in the business, therefore you took my money in the business, therefore you converted us to yours. Ninth claim, unjust enrichment. It should have been mine. Negligent infliction of emotional distress. By the actions complained herein, the Westbrooks' extreme and egregious actions have caused plaintiff and or plaintiff's immediate family to suffer extreme emotional distress and ultimately death. Look, it sucks that the father-in-law passed. Always unfortunate when somebody passed. It's going to be hard to tie these together for NIED, I think. But that's why they put it in there. That explains why that sentence is in there, because they added the NIED and the IIED. Strategically, I can understand why they did, because then it lets you, if this all goes to trial is going to be like this. And it's like, no, they did this. No, they did this. No, they did this. And it was so bad that it caused this. This is the ramping up of hostilities between the parties. IIED is the next cause of action. Intentional infliction of emotional distress. 12th claim for relief, breach of contract. Breach of implied covenant of good faith and fair dealing, which they are also suing him for. Accounting, we want to know what costs what. Plaintiffs request the court order an accounting of 1, all monies which the Westbrooks have inappropriately taken from the business, All monies the Westbrooks have caused the business to spend on frivolous lawsuits. Bro. Okay. The reason I laugh is because this comes immediately after they get attorneys, the Westbrooks and Halo get attorney's fees for having to deal with Clark's fuckery. So for Clark to turn around and be like, you're spending all this money on frivolous lawsuits, it's like, bro, you're the one bringing the lawsuits that we're spending the money on. I wonder if he's referring to the YouTuber defamation suit, because Halo Beauty was a party to the YouTuber defamation suit too. I wonder if that's what he's referring to. Maybe that's what he's referring to. 3, all monies which the Westbrooks have caused the business to spend in furtherance of the Westbrooks' personal agendas, lawsuits, and endeavors. That's broad. But Clark was the first one to sue. Clark sued the Westbrooks and said, this is a lawsuit because of the defendant's greed. Sued at a time when Tati was still really off the internet after the Bi-Sister scandal, and it got picked up by international media because of the way it was written. I mean, there was tea in there. We read it. It was like, ooh, okay, spicy. But to say that the Westbrooks are the ones bringing the frivolous lawsuits it's just a bit disingenuous to me, because shots fired started with Clark. All right. 15th claim for relief, reformation, the reformation of the business. Good luck. Swanson is entitled to a reformation of the parties' agreement, retroactively putting him back to 50% owner of Halo. Okay. 16th claim for relief, preliminary and permanent injunction. What do you want to enjoin the Westbrooks from doing? This is interesting. Let's see. Defendant's actions complained of herein, not limited to, causing the jointly owned business to fund the prosecution of their personal and unfounded claims against Swanson, and or causing the jointly owned business to fund their efforts to defend against Swanson's claims against them personally, and has caused and continues to cause Swanson to incur irreparable harm. Swanson's likely to succeed on the merits of his claim. Swanson has no adequate remedy at law. He wants the Westbrooks to stop paying Halo money for these lawsuits, but Halo's part of it. Okay. Swanson is entitled to a preliminary and permanent injunction that compels and requires the Westbrooks to give Swanson real-time access to all the books and records of the business. The court just gave these not that long ago. The court had to force Swanson to give all the books back to the Westbrooks. Oh my God, business litigation. Business litigation is fascinating, but there's so much. There's so much. Prohibits the Westbrooks from causing the business to undertake any action which is not in the best interest of the business. Prohibits the Westbrooks from causing and allowing the jointly owned business to fund the prosecution of the Westbrooks' personal and unfounded claims against Swanson. Those claims have now been yeeted. I think all of them. Prohibits the Westbrooks from causing or allowing the jointly owned business to fund the Westbrooks' efforts to defend Swanson's claims against them personally. Direct and proximate result of the Westbrooks' action. Swanson has been damaged in the amount excess of $15,000. That's the statutory amount. 17th claim for relief, conspiracy.
It's a conspiracy. But is it also building monuments to the gods of speculation? I have questions.
Defendants acted in concert in undertaking the actions complained of herein with the intent to accomplish the unlawful objective for the purpose of harming Swanson. As a direct and proximate result of defendant's actions, Swanson has been damaged. The actions of defendants were intentional. Breach of fiduciary duty, which is they're suing him for too. Who's Donovan? What the fuck is happening? Due to the relationship of the parties, the Westbrooks owe and have owed certain fiduciary duties to Swanson. They say the same about him. The Westbrooks breached their fiduciary duty to Swanson. The Westbrooks' actions are in denial of or inconsistent with Swanson's rights. As a direct and proximate cause of Donovan's actions or inactions, Swanson has incurred the damages. I think that's a cut and paste error. Because I'm like, wait, who's Donovan? Stop. You can't add new players in cause of action 18. It's too confusing. All right. So they're asking for the statutory amount and all of the other stuff in the prayer for relief. And that is the end. So this is a substantially less salacious version of the same allegations that were made in California. So we will keep an eye on this to see what happens. There will be a response from the Westbrooks. I wonder if we will see a motion to dismiss regarding statute of limitations. So the Westbrooks are litigating against Swanson with Halo Beauty, and now Swanson is again litigating this third time, maybe. This is the third time he's filed essentially these causes of action against the Westbrooks, now in Nevada. We need to move on. We need to move on to talk about these cease and desists. I'm ready. I'm ready for the C&Ds, man. They're spicy. Let's go ahead and end the poll. And then we need to talk about which cease and desist we go over first, because there are a bunch of them. I think we just go for the spicy ones and we leave the other ones alone. There are so many of them. All right, let's go to the Diana Jenkins cease and desist. Some of them are against YouTubers. Some of them are against podcasters, and we will do it. You've probably already seen some of them. Is James Westbrook also YouTube famous? 82% no, 17% yes. So there we go. I think that tracks, that James is the kind of the behind the scenes. He's known, but I think Tati is the face of that YouTube channel. All right, cease and desist. Real Housewife of Beverly Hills, Diana Jenkins. If you are not watching Real Housewives of Beverly Hills this season, you're probably like, I'm sorry, who? Has filed all of these cease and desists. We're going to go through some of them. Some of them repeat a lot of the same shit. She's not having it. A lot has been going on online. If you don't watch my friends Up and Adam and Zach Peter, they do a lot of commentary on Housewives and have been covering it. I love Talk of Shame over on Instagram, and I love Dame Galley, Sarah Galley's podcast, Andy's Girls. Who else is covering this? I'm pretty sure Ryan Bailey has covered this as well. A lot has gone down on social media with regard to this season of Real Housewives of Beverly Hills. But next to that, we got a whole fleet of cease and desist because Diana's sick of people talking about her. Though in some of these, I'm like, if you can't prove that, you can't say that. And all of these cease and desist had a response day of yesterday. So we will see what happens. I don't know if any of the complaint about content is still up or has been taken down. I will let you all go take a look around the interwebs, but let's get into this. I'm going to tell you all the people who have cease and desist, and then we'll go one by one. So first cease and desist is, or first one that in the order I uploaded them in, is to Dana Wilkey of Dishing Drama with Dana Wilkey, who is a podcaster and had been on one season of Housewives. To Enty Lawyer, Enty Lawyer. I'd never heard of them. There's one to them. There's one to Gawker. There's one to Heavy Ink. There's one to Jezebel. There is one to South China Morning Post. One to Laura Marie and Casey O'Donnell of the Sexy Unique podcast. One to Tarina Sharrelle Lloyd, aka Sharrelle from Sharrelle's World, here on YouTube. So we're going to go through those. Where should we start? Podcasts and YouTube? I feel like we should start with podcasts and YouTube, and then we'll work our way backwards to Gawker and Jezebel. How about that? How about that? All right.
25,000.
There we go, Noelle. All right. Let's get started. We're going to start with the one for Sharrelle's World and take a look for there. All right. Oh, I'm going to say all the words. YouTube is going to be like, girl. So here we go. Just do the YouTube things and like and subscribe. I'm going to say all the words in this, and YouTube is going to hate it. But also, I'm going to say all the words. We're leaning into the monetization or lack thereof today because I want to say all the words, and we're going to say all the words. There's a lot of words in here. These aren't my words. These are the words in the cease and desist. YouTube.
It's a legal document. It says dick a lot.
So let's get into it. Just all the words. I'm saying all the words. Just here they go. I don't know if I don't know if this content is still up or not still up. Demand to cease and desist publication of false and defamatory statements about Diana Jenkins from August 31st. I would have covered this sooner, but traveling. Dear Mrs. and Mr. Lloyd, my firm represents Diana Jenkins. This letter concerns your multi-month campaign of making numerous false and defamatory statements on your YouTube video show. Not a YouTube video show. Lawyers, YouTube channel. Just say YouTube channel. Just say YouTube channel. Okay. People are asking, what kind of legal document is that? It's a cease and desist. I'm not bleeping the words. Oh, I can bleep some of them. We can bleep some of them. We can bleep some of them. Does Facebook do the same shit YouTube does with words? Oh yeah, YouTube gets even crankier. This might have to come down. It might. Oh, it's a stack. It's a stack of cease and desists. Yes, it is. YouTube show. Okay, look, it's not a YouTube video show. This isn't like Video Killed the Radio Star. This is just a YouTube channel. Lawyers. That's how we colloquially refer to them. On your YouTube channel, Sharrelle's World, regarding Miss Jenkins, including your June 16th, 2022 YouTube video titled Diana, Real Housewives of Beverly Hills, outed for being a madam. Lisa and Erica target sudden and recap review in which you repeatedly state, one, Miss Jenkins is a prostitute and a madam, and otherwise insinuate that she is such by repeatedly calling Miss Jenkins a quote-unquote hoe or quote-unquote the main hoe in charge. Is the main hoe in charge an opinion? That might be an opinion. Quote, a Beverly Hills pimp and quote, and two, Miss Jenkins' book, Room 23, was a book of Miss Jenkins's Johns and Prostitutes, footnote 1, and they link the YouTube video. Now, the book, look, there are lots of rumors about the book. We are going to see this on and on again. She said it's an art book. The book came up. She did not want to talk about it at all at the beginning of the season. So the book is an art book with boudoir photos is my understanding. I don't think you can get this book. It's out of print, but this is the cover of the book. Diana Jenkins represents Room 23, and it's boudoir photography. According to the show, let's just read the description of the book from Amazon. How about we just do that? Room 23 depicts a year in the life of a private penthouse suite in a hotel in Beverly Hills, California. The year is 2008. The protagonist, Hollywood characters and elite. The host, Diana Jenkins. The photographer, Deborah Anderson. The photographs glamorously unveil the story of what takes place behind these closed doors in provocative and intimate images. Some of the guests in Room 23 are Ashanti, James Blunt, Robert Caviezel, Roberto Cavalli. God damn it, my brain. My brain just went. George Clooney, Cindy Crawford, Minnie Driver, Dennis Hopper, Rachel Hunter, Sir Elton John, Kid Rock, Heidi Klum, Ray Liotta, Lindsay Lohan, Kelly Lynch, Tamara Mellon, Johnny Lee Miller, Moby. I can't pronounce Tatiana, I think, Peretz, Christian Slater, Sharon Stone, Donald Sutherland, Cheryl Teagues, Tony Ward, and many more. We got to find this book. Somebody's got the book. We'll have to find the book. Anyway, that is something we had to address because this is going to come up a lot. I thought for those that don't watch the show that talking about the book might help. Yeah. All right. That's not what I wanted. That's what I wanted. That is what I wanted. Let's see. Your June, so that's the book. All right, your June 17th, 2022 YouTube video entitled Ex-Prostitute Diana Jenkins, Real Housewives of Beverly Hills calls out Black blogger Kyle and Mauricio split news, in which Miss Lloyd, one, repeatedly stated that Miss Jenkins is an escort, a prostitute, a madam, and otherwise insinuates such by stating, among other things, that Miss Jenkins is a quote-unquote hoe, a quote-unquote hooker, a quote-unquote whore, a quote, dirty cocksucker that sucked her way to the top. Is that opinion? Quote, sucked dick for a living, quote, blows men for money, quote, laid on her fucking back, participating in nasty ass threesome, licking the balls of people she didn't even know, quote, licked the balls of people with money, and quote, blew her way to the top dick after dick. 2, stated that men peed on Miss Jenkins for money. That's oddly specific. 3, stated that Miss Jenkins' book, Room 23, was a book about Miss Jenkins' Johns and prostitutes. 4, showed an Instagram post from an account, Northeast Housewives, stating, among other things, that Miss Jenkins, quote, pimped out the vulnerable Hayden Panettiere, who had been abused in childhood, to sick men for profit. By the way, these are allegations of crimes. So when you get into the allegations of crimes are an opinion. There is between alleging somebody like sucked dick to move their way to the top is one thing. Alleging they did it for money is technically alleging a crime in most jurisdictions. And then when you get into the pimping out people, you are definitely alleging a crime, and that can become problematic if it is not proven. So somebody's asking, who cares? She cares. Alexandra, she's sending a cease and desist. Diana Jenkins cares very much. That is why she is sending a cease and desist. So, Hogue is not watching. Hogue has clicked off immediately. There are no allegations of a stack that I can see. So I missed the rest of this allegation. The allegation that Miss Jenkins pimped out Hayden Panettiere, who had been abused in childhood, to sick men for profit. 5, had a guest named Mel NYC Reviews, who stated that Miss Jenkins was a sexual predator. Again, those types of allegations can be they are much harder to say that those are opinion when you are saying that people are engaged in illegal act or illegal acts. Repeatedly stated that Miss Jenkins participated in sex trafficking, and that's where you're gonna have a problem in a defamation case of young women and children, including, among other things, that Miss Jenkins, quote, sent people to Jeffrey Epstein and, quote, forced young women to be with men, forced them into threesomes, do their kinky acts, pee on them, and shit on them. Look, we're not going to kink shame anybody. It's the trafficking that is the problem. Took innocent people and ruined their lives, ruined someone's lives, and many women, and was no better than Ghislaine Maxwell, who is, of course, a convicted felon. So here's the problem. Some things might be seen as an opinion, and some things you might be able to be like, that's an opinion. Did you suck dick on the way to the top? That might be an opinion. But when you get into trafficking allegations, it's going to be problematic. Now, if these things are all down, sending out the cease and desist can also kind of Streisand affect the thing, where if all of you haven't watched the video, now you know what was said when you might not have known before. But this is where we're going to start seeing celebrities in defamation suits more and more, because how do you unwind allegations like this? So let us continue. Your June 24th, 22 video titled Ex-Madam Diane Jenkins Lawsuits, plus Erica New Lawsuit, plus Real Housewives of Beverly Hills Recap, plus Review, in which you repeatedly say that Miss Jenkins is a prostitute, a madam, and a sex trafficker. Sex trafficking, by the way, is going to be the most problematic. I mean, the others are problematic, but sex trafficker, when you're looking at like a defamation per se, I think that's going to be the most problematic. Your June 28th, 2022 YouTube video titled Real Housewives of Beverly Hills Behind the Scenes Chaos. Diana Bad Behavior to Garcelle, plus Room 23 pick, plus Cherie Zampino, in which Miss Lloyd 1 repeatedly stated that Miss Jenkins is a quote-unquote sex trafficker, or otherwise insinuate as such by stating, among other things, that she is a female Epstein and needs to be in prison like Ghislaine Maxwell. Those are problematic accusations. Of course, these are accusations. This is a cease and desist, and this assumes, again, that the parties stating it don't have proof that it's true. Because again, 2, repeatedly stated that Miss Jenkins was a madam. 3, that Miss Jenkins' book, Room 23, was a book of Miss Jenkins' Johns and prostitutes. Footnote 4, and these are all the videos. Your June 30th, 2022 YouTube video titled Diana Jenkins Real Housewives of Beverly Hills, deplorable acts. Sutton takes her on and Lisa Rinna defends her, plus recap in which Miss Lloyd stated that Miss Jenkins is not only a madam, but also participated in child sex. Awful shit, exploitation and abuse. Those are the words that are going to do it for the YouTube folks. We're talking about a lawsuit, YouTube. For example, Miss Lloyd stated that Miss Jenkins had some kids do unthinkable things for people's fetishes, forced children to do unthinkable. That's going to get you on the defamation. If you can't prove that, that is going to get you on the defamation. All of that is going to get you on the defamation per se. If again, assuming that this is quote for quote verbatim what was said, you would have to very well be able to prove it, because unless there's context saying, hey, this has been said by this person. When you go back and look at like the Ethan Klein Kavanaugh stuff, Ethan's like, look, Variety reported that Ethan Klein's business partner alleged that he ran a Ponzi scheme. That is different than saying this person did this. This person has been alleged to have done this. Even when you're getting into these kind of allegations, is a problem. Yeah. Though, I don't know. Oh, Diana seems to have more money than God, so I don't know if she wants to continue. I mean, what are you going to get? If the videos come down and people comply with the cease and desists, perhaps they will just move away. Oh, it is now pouring rain. Of course it is. Okay. Oh, this one isn't done. All right. Is getting away with the most atrocious acts and did not have time to donate to charity because she was too busy taking advantage of children. Yikes. On July 1st, 2022, a YouTube video titled Diana Jenkins, Real Housewives of Beverly Hills to be fired. Lisa Rinna windmills for her. Real Housewife of Dubai, Chanel, and cast upset, in which Miss Lloyd stated again that Miss Jenkins is a sex trafficker, including of children, and insinuating as such by calling Miss Jenkins the R. Kelly of Beverly Hills. The false and defamatory statements made by Miss Lloyd during your July 6, 2022 YouTube video titled Hayden Panettiere, Diana's Real Housewife alleged victim, speaks on her addictions. Like, how did Hayden Panettiere get roped into all of, like, what is happening? In the video, Miss Lloyd stated that Hayden Panettiere, I don't know why I'm saying that weird. Hayden Panettiere was one of Miss Jenkins' sex trafficked victims. Like, when you start naming people and alleging that they've been victims of horrible shit, it's hard for my brain. Because, again, this all stays on the internet forever. Has Hayden Panettiere come out and said that and I didn't know? Because come on. Because no. Like, leave Hayden Panettiere's name. Look, here's where I'm at just personally. If this had happened to someone, this happens, children are victims of sex trafficking, that happens. But connecting their names to it in legal filings, they would be done by initial. So connecting someone's name with this is hard for me, because I don't know if there's any proof that this is ever something that happened. But if a celebrity was harmed and victimized in that way, maybe just leave their name out of it so that it is not connected to them for the rest of their life as they are trying to recover from the horrible things that were done to them. I don't understand where this came from. And it's just, now it's just out there. Yeah, this did get really bad fast. I see you, chat. This got bad really fast, and this is the first one. Like, leave Hayden Panettiere alone. Miss Panettiere's July 6, 2022 interview with GMA showed the ugly side of sex trafficking. I haven't seen that interview. Lloyd then played a clip from the interview that has a very prominent banner stating Hayden Panettiere opens up actress on battling postpartum depression and alcoholism. That's not sex trafficking, though. Shelby, I agree with you. These video titles and defamation claims are looking more Cardi B versus Tasha K than H3 Kavanaugh. I agree with you. And again, postpartum depression, serious shit, but not sex trafficking. Miss Lloyd then later stated that there was a P file associated with Jenkins and that Jenkins made children do unruly acts. Your July 7th, 2022 YouTube video titled Ashanti and Diana Jenkins' Secret Connection, Kyle Gaslighting, and Real Housewives of Beverly Hills recap, in which Lloyd again stated that Miss Jenkins was involved in sex trafficking, including sex trafficking children. Look, though we always need context to the way things were said. Always need context in the way things were said. But none of these sound like it's alleged that in this publication said this. This sounds like that is being repeated over and over and over. And this is in that defamation per se realm. This is, accusing someone of sex trafficking children is going to fall into defamation per se. And I don't know how you defend that. How do you have evidence to defend that? Short of someone being investigated and convicted by like the federal government. These are allegations that should never, ever be thrown around lightly. Because again, when they happen, that is when it should be discussed. All right. Your July 14th, 2022 YouTube video titled Chloe K lies about Tristan relationship and baby. Andy Cohen responds to Jen Shaw recap, in which Miss Lloyd stated that Miss Jenkins was a madam and a sex trafficker. Your July 22, 2022 video titled Lisa Rinna, Harry Hamlin, Twisted Love Affairs, Kathy's Cover Up, and Diana's Quits Hollywood, in which Miss Lloyd, one, yet again repeatedly stated that Jenkins was a madam sex trafficker and participated in sex trafficking rings. Two, that Hayden Panettiere and Amanda Bynes were victims of Miss Jenkins' sex trafficking ring, and that Robert Downey Jr. confirmed this. Three, insinuated that Miss Jenkins provided children to elite men, including politicians and powerful producers, for sex so that she would get away with it because she paid off the right people, including politicians. Your August 17th, 2022 YouTube video titled Diana Jenkins and Lisa Rinna not returning to Real Housewives of Beverly Hills, and Denise Richards wants to be back on the show, in which Miss Lloyd again states that Miss Jenkins is an escort, a madam, and a sex trafficker. Wait a second. Your August 2022 video titled Diana Sutton Garcelle are bullying her. The word bullying is the thing that gets edited. That's the problem. The word bullying is the problem in the title. What? 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 That's what gets, look, trying to connect Amanda Bynes, who just got out of a conservatorship, to being a victim of sex trafficking is just so wild. But then bullying is what gets redacted in the title. This isn't an auto censor. This is a YouTube video title that the attorneys are just taking the exact video title as it appeared on the platform. YouTube doesn't do that with titles. In which Miss Lloyd again stated that Jenkins is a sex trafficker who not only harmed young women, but also children, and referred to as a Glenn Maxwell reject. Footnote 13. Yeah. I have not watched these videos, but I can understand why they filed a cease and desist. I can understand why they filed a cease and desist. Look, man, there's a difference between like saying mean shit on the internet and defaming people. It's going to be real hard to prove some of the things that are said here. You would have to have quite a lot of proof to stand this up a trial, and it would cost quite a lot of money to do so. I just don't know. YouTube is very, very offended by that particular B word, not by the content, but by that word. Okay. All right, let's see what this letter requests now that we're past the things that were said or the things that they allege are being said. Because again, this is a cease and desist. So we are past the things that they are saying are defamatory. These videos may or may not be down. You must immediately remove these false and defamatory statements and any similar false and defamatory statements and issue notices acknowledging that you had no factual basis for any of the statements and implications made about Ms. Jenkins. Your continued publications of these statements will be met with immediate legal action. I imagine it would be. First, the statements and implication that you have made and published about Ms. Jenkins are demonstrably false. Ms. Jenkins has never engaged in illegal and immoral activities you have accused her of doing. It should go without saying, but it shall be said to avoid any confusion. Ms. Jenkins has never engaged in prostitution, sex trafficking, child sexual abuse, bribery, or any of the other assortment of misdeeds you have claimed. You have deliberately chosen to publish falsehoods. This is most obviously demonstrated in your July 6 YouTube video, where you claim that Hayden Panettiere was a victim of Ms. Jenkins. Ms. Panettiere gave an interview to GMA regarding the ugly side of sex trafficking, when the banner of the very interview clip you showed stated that she was discussing her struggles with postpartum depression, a medical condition completely unrelated to being a victim of sex trafficking. Second, there is no credible source for the claims you have made and published about Ms. Jenkins. The claims about Ms. Jenkins are completely fabricated, and as of such, no credible source can possibly exist. Moreover, you are surely aware that Ms. Jenkins and others have published statements refuting these defamatory and disparaging claims. Your original and continued publication of defamatory and disparaging claims as discussed above, notwithstanding your knowledge that they have been denied and refuted by Ms. Jenkins and others, is a textbook case of actual malice. Third, you are legally responsible for the false statements that you have made, the false statements made by your guests, and the false statements that you have repeated. Defamation liability attaches to the publisher of false statements, and you are the publisher of your YouTube show. I mean, with everything that was said, they can try to throw that point on there. There's a legal point to fight, but that's not the point to fight on because there's so much else said. This is not just a guest saying things. Wow. Yeah. You must know that Ms. Jenkins can and will easily establish these statements you made about her were false and defamatory. Likewise, you must know that Ms. Jenkins can and will easily establish that you acted with actual malice because these claims about her are fabricated. The truth about Ms. Jenkins was readily ascertainable and no credible source exists. I mean, it sounds like she's already denied the things that are being repeated here. You have accused Ms. Jenkins of crimes as well as heinous immoral activities. Reputational harm is presumed. Yeah, that's the defamation per se of it all. You've put yourself in a precarious and potential ruinous position. Oh, here's the govern yourself accordingly of the cease and desist. You've put yourself in a precarious and potentially ruinous position. Perhaps you believe that a quote unquote get out of jail card exists because you run a banner throughout your show saying everything in this video is alleged and in our opinion, and therefore you can persuade a court or jury that your statements about Ms. Jenkins are quote unquote pure opinion. That is not going to happen. As an initial matter, you have repeatedly made the above described statements over multiple months, creating an obvious inference that these are facts and not opinions. In addition, you have held yourself out as someone that your audience can and should rely on for uncovering facts. You would have no audience if you acknowledge that everything you say is pure, hateful make-believe. Strongly worded cease and desist. You've branded yourself as someone your audience can trust for facts, and you have used that brand for purposes of self-promotion and enrichment. I mean, that's how YouTube works. These facts alone foreclose the pure opinion defense. I take a little bit of issue. However, the statements are rough. So I take a little bit of issue, but of course the strongly worded cease and desist is going to be hard to fight with on this one. But I don't think it's as cut and dry as they will make it. But I also think one of those statements is enough that a jury would be like, no, there are boundaries. There are boundaries here. And it goes beyond, like when you are shaming women for like sleeping their way to the top, there, I guess, will be an argument that this is opinion or conjecture or whatever. or just spite. But when you accuse people of child abuse, trafficking, and start joining in names of supposed victims, it's going to cross a lot of lines. That's going to be real expensive to get into litigation over. Further, you have eliminated the pure opinion defense by telling your audience that your statement about Miss Jenkins are based on facts. Well, whoop, there it is. I would need more context to that, but I'm interested what they say. Because if true, that's problematic. For example, during the June 17th, 2022 YouTube video, Miss Lloyd stated, "No, I'm not dragging her. I'm telling the truth." I would need context. And I'm not sure why you're laughing because I'm telling the honest truth. I would need to know which statements that's in connection to. These are where I have questions. It's all great clipped out, but what is that in relation to? And I would need more context for that. But I could see why they would say I'm telling the truth would expand to everything, or they would try to make it. This would be too expensive to fight though. So I don't even know if you'd want to fight the context on it because that becomes so picky. It doesn't matter. Similarly, Miss Lloyd stated during the July 6th and 7th YouTube videos that Miss Jenkins needs to be held accountable for the things that she has done and needs to be held accountable. I would need context. Similarly, during the June 24th, 28th, 30th, 1st, and July 22nd and August 22nd videos, Miss Lloyd repeatedly stated Miss Jenkins was getting away with and is never going to pay for the alleged described conduct and or needs to be in prison for the above described conduct. Additionally, many of the videos have titles that plainly state as purported facts that Diana was outed for being a madam, ex-prostitute, ex-madam. Beyond the obvious legal issues, there are definitely legal issues here. What you have done to Miss Jenkins is simply wrong. She is a mother, a philanthropist, and an entrepreneur. Her philanthropic endeavors are well known and have generated millions of dollars in the assistance. Sorry, the rain scared me. I don't know if you guys can hear that. Has generated millions of dollars in assistance for victims of human rights violations, natural disasters, wars, and health epidemics. To characterize her as a prostitute, madam, sex trafficker, child abuser, and criminal is not just factually inaccurate, but ethically wrong. This is not entertainment. This is someone's life and reputation. Your YouTube show may give you an audience and advertising and other revenue. That's how YouTube works. But it does not give you a license to defame. I agree with that. And disparage Miss Jenkins. There are real world consequences for your actions. Here's your cease and desist. Fuck around and find out. We have the money and we will sue you. That is what that sentence says. Your publication of the false and defamatory statements must stop. You have already done enough damage to Miss Jenkins and her family. To mitigate the continued accrual of these damages, you must take down all of your identified videos, remove all mentions of Miss Jenkins from your social media accounts. See, here's the thing where it reaches too far. Like all mentions, like take her name out of your mouth entirely. But that's not it either. Though that might happen to comply with the cease and desist, you can still talk about people. You can't defame people. But when the line has been crossed, of course, they're like, get my name out of your mouth and never whisper a breath of it again. Remove all mentions of Miss Jenkins from your social media accounts, including YouTube, Twitter, Instagram, TikTok, Facebook, or any others. Issue a corrective statement on your YouTube show indicating that all of your past statements about Miss Jenkins are factually inaccurate and you had no basis for making them. 4, issue a written apology to Miss Jenkins for publishing false and defamatory statements about her. Please confirm by 5 p.m. Eastern Time on September 2nd that you will be taking these actions. That was days ago. Further, be advised that Miss Jenkins reserves all legal rights. Like, we will sue the fuck out of you. But again, man, you can't. The internet continues to get wild. And when it comes to celebrity reputation, we are going to get more defamation lawsuits like this. We just are. We are going to continue to see them. Because people, what do you have if not your reputation? All right, let's look at the one for Dana Wilkey, and then we will look at a few others real quick and get to questions before my voice completely gives up. Dana Wilkey, dishing drama with Dana Wilkey, demand to cease and desist publication of false and defamatory statements about Diana Jenkins. My firm represents Diana Jenkins, Neuro Drinks, Neuro Brands, and D Empire Entertainment. Damn it. What is the D, though? But what? Damn it. What's the D? This letter concerns a number of false and defamatory statements published by you across multiple media platforms, including. I like that they just get into it. They just list out the things that they think are defamatory. Your November 10th, 2021 YouTube video titled New Real Housewives of Beverly Hills cast member Diana Jenkins' shocking story, Room 23 and Season 12, Real Housewives of Beverly Hills, in which you falsely state that Miss Jenkins had extramarital affairs with Rio Ferdinand, Justin Timberlake, and Guy Ritchie. The false and defamatory statements made by you and your guest. Though, I don't know. Accusing someone of affairs is, I don't know. Interesting. I mean, how much does it damage your reputation? It's not defamation per se. That one's harder than some of the other things we've seen. The false and defamatory statements made by you and your guest, Enty. Is that Enty? Is that how we pronounce that? Enty Lawyer, during the May 15th and May 22nd episodes of your podcast, Dishing Drama with Dana Wilkey, including 1, that Miss Jenkins engaged in extramarital affairs, 2, that Miss Jenkins is the reason that Barclays has been in trouble for the last 13 or 14 years due to a connection with a Qatari sheikh, 3, that Miss Jenkins is connected to Muammar Gaddafi and has received stolen funds associated with him, 4, that Room 23 was a sex trafficking book and that Miss Jenkins has always been involved in the sex trade, 5, that Miss Jenkins was introducing Hayden Panettiere and other celebrities to men and women who would pay them for sex, 6, that Miss Jenkins, through her charitable foundation, was involved in the in the assassination of the president of Haiti, 7, that Miss Jenkins facilitated the sale of a 14-year-old Bosnian girl to Jeffrey Epstein, 8, that Miss Jenkins and Sean Penn have been involved in trafficking young women across continents, 9, that Miss Jenkins connected Mr. Penn to Eastern European strippers, 10, that Miss Jenkins had affairs with Rio Ferdinand, 11, that Miss Jenkins brought a group of models and prostitutes to party with Mr. Ferdinand, 12, that Miss Jenkins has been paid in exchange for performing sexual acts, 13, that Miss Jenkins was a madam, 14, that Miss Jenkins was involved in embezzlement and tax evasion crimes, 15, that Miss Jenkins utilizes a website for her illegal activities that is also used by, quote, people who deal in CP and stuff like that. I've said all the words. YouTube is already pissed about this video. 16, that Miss Jenkins did not make a payment pursuant to a settlement agreement. Really? That's what we're throwing in there? We're throwing in there that she didn't make a payment with regard to a settlement agreement? That's what we're mad about in all of this? Bury that one at the end. Put that one in the beginning. Don't put it in the middle of child porn and sex trafficking. For fuck's sake. Maybe they just went in the order of what it was said. Oh, man. 16, settlement agreement. 17, that Neuro Drinks, Miss Jenkins's functional beverage line, is a, quote, soft drink that gives you sex drive. Wait, are we mad about that? Is it not? It's a soft drink that gives you sex drive. Maybe. Is that defamatory? I feel like that's not defamatory. Let's keep going. Maybe there's context that makes it defamatory. I'm like, what is happening? Oh my God. What is happening? Okay. Sorry, the soft drink gives you sex drive. 18, that Miss Jenkins' Neuro Drinks business is a quote unquote front being used to launder money. 19, that the music label founded by Miss Jenkins, D Empire Entertainment, is being used to launder money, is not a legitimate business, has connections to Malaysia. I'm sorry, my brain just went to Zoolander. I apologize. Implying that it's used for purposes related for sex trafficking. Oh God. 20, that Miss Jenkins is lying about her involvement in humanitarian causes. 21, that Miss Jenkins met Mr. Penn in the course of providing him with prostitutes. 22, that Miss Jenkins and Mr. Penn had an extramarital affair. 23, that Neuro drinks are not available for purchase and therefore not a legitimate business. You can't buy the sex drink. 24, that Miss Jenkins was involved in laundering money through the Vatican Bank. Well, that's messy. That's That's a lot. Your June 23, 2022 YouTube video titled Real Housewives of Beverly Hills, Season 12, Episode 7, X Gossips Erica's Yacht Illegal and MX Messy, in which you falsely imply that Miss Jenkins' first purported introduction to her now fiance, Asher Monroe, was at a Victoria's Secret fashion show, was connected to sex trafficking. Wait, the Victoria's Secret fashion show was connected to sex trafficking? I'm so confused. Specifically, I write to demand that you immediately remove these false and defamatory statements and issue notices acknowledging that you have no factual basis for the statements and implications made. Your continued publications of these statements will be met with immediate legal action. And then this is going to be a lot of the same of what we already said. This is kind of cut and paste from the other ones. First, the statements and implications you have made and published about Miss Jenkins are demonstrably false. She has never engaged in the illegal and immoral activities you have accused her of doing. It should go without saying, but it shall be said to avoid confusion. So that's all cut and paste. Let's see. This is all the same from the other cease and desist. You've put yourself in a precarious and potentially ruinous position. Perhaps you believe a get-out-of-jail-free card exists if you can persuade the court that your statements about Miss Jenkins and her companies are pure opinion. That's not going to happen. You have held yourself out as someone that your audience can and should rely on for uncovering facts that you've that is how you've built yourself and your brand as someone who previously appeared on The Real Housewives of Beverly Hills. Your reputation hinges on having access to accurate behind-the-scenes information on The Real Housewives. You describe yourselves in social media profiles as a real-life Lady Whistledown with a touch of Elle Woods, emphasizing your access to insider information. You do not promote yourself as a purveyor of make-believe. You have branded yourself as something else for the purpose of self-promotion and enrichment. These facts foreclose the pure opinion defense. I think that's strongly stated. I understand the lawyer's position. I think that's strongly stated. But when you start saying, it's a touch of Elle Woods, the lawyers are going to get up and argue. See, she holds herself out as a pseudo lawyer. That's the type of thing that they will argue. Let's see. Beyond the obvious legal issues, what you have done to Miss Jenkins is simply wrong. She is a mother, a philanthropist, entrepreneur. Her philanthropic endeavors are well known and have generated millions of dollars. To characterize Miss Jenkins as an adulterer, sex trafficker is criminal and is not just factually inaccurate but ethically wrong. Her companies are a success on their own accord. Neuro drinks are sold in Walmart stores across the country and on Amazon. To reduce her companies to purported money laundering fronts is not only factually inaccurate, but harmful to the individuals employed by her companies. I mean, it's also accusing them of crimes, which can lean into the defamation per se. Your podcast may give you an audience and subscription sales, but it does not give you a license to defame and disparage a woman and her company. There are real-world consequences for your actions. I really appreciate the govern yourself accordingly of it all. This is the legal fuck around and find out. There are real-world consequences to your actions. Your publication must stop. You have already done enough damage. To mitigate the continued accrual of these damages, you must, 1, take down both the free and subscription versions of the May 15th and May 22nd episode of Dishing Drama with Dana Wilkey, titled Deep Dive on Sanella Diana Jenkins with Enty Lawyer, Parts 1 and 2 from Patreon and all other podcast streaming platforms. 2, remove all mentions of Miss Jenkins from your social media accounts. 3, issue a corrective statement on your podcast and social media profiles indicating that all your past statements about Jenkins and her company are factually inaccurate. You have no basis for making the statements. 4, issue a written apology to Miss Jenkins. You have till 5 p.m. September 2nd. All right. That's 2 of the 1, 2, 3, 4, 5, 6, 7, 8 that were sent out. Let's take a look. I don't know who this individual is, but this is a quote unquote Enty Lawyer. It's redacted out appropriately. Cease and desist. My firm represents Diana Jenkins, Neuro Drinks, Neuro Brands, D Empire. This letter concerns a number of false and defamatory statements. Your January 1st, 2019 post on Crazy Days and Nights blog titled Blind Items Revealed number 38, in which you falsely imply that Miss Jenkins facilitated prostitution and child sex trafficking. Footnote 1. Your November 2nd, 2020 21, tweet in which you falsely state that Miss Jenkins' book Room 21 is, quote, a front for celebrity prostitution, and that, quote, she spent a lot of time with Jeffrey Epstein. In addition to the tweet, you use an April 8th, 1997 photo, including Donald Trump, Jeffrey Epstein, and Belgian model Ingrid. I cannot get that right. Senhave? No offense, Ingrid. I'm just really bad at pronouncing things. Falsely indicating that Ingrid is Miss Jenkins. Oh, that's not good. Your November 3rd, 2021 tweet in which you falsely state that Miss Jenkins moved her partner Asher Moore into her house and was sleeping with him beginning when he was 16, thereby accusing her of statutory rape. How would people know that? Your false and defamatory statements during the May 15th and May 22nd episodes of the Dishing Drama with Dana Wilkey podcast, and this is everything that we just read in the last one. Specifically, I write to demand that you immediately remove these false and defamatory statements. First, your statements and implications about Miss Jenkins are demonstrably false. Your false claims regarding Room 23 illustrate your reckless disregard for the truth. Room 23 is a fine art coffee table book featuring photos of countless celebrities, including Cindy Crawford, Heidi Klum, Sharon Stone, Kenny G, Larry King, Kid Rock, George Clooney, Kelly Lynch, James Blunt, Jessica Stamm, Lindsay Lohan, and others. Well, that's a list. It is not a quote-unquote catalog of any sort, much less a sex trafficking book as you claim. The list of participants in that project alone makes that plainly clear. Your repeated mischaracterization of the project that Miss Jenkins self-funded in order to raise money for combat war crimes, genocide, and human rights violations is indefensible. Second, there is no credible source for your claims. By way of example, you falsely identify Miss Jenkins as being photographed with Jeffrey Epstein. You do so to create the implication that Miss Jenkins had a relationship with that person and to taint Miss Jenkins as someone who would participate in the same illegal and immoral behavior as that person. Yet you surely know that the woman in the picture is Ingrid, not Miss Jenkins. Miss Jenkins, for one, explained that she is not the person in the picture. Moreover, Miss Jenkins was never in the same room with that person. Your persistence in trying to make fetch happen, notwithstanding her refutation, proves that you intend to defame her. I added the make fetch happen. Well, I'm reading this for anyone listening and not looking. I just paraphrased. You must know that Miss Jenkins can and will easily establish the statements you made about her and her business are false and defamatory. You put yourself in a precarious and potentially ruinous position. You have held yourself out as someone your audience can rely on for facts. That is how you have built your following and brand. That is why you use the term lawyer as part of your handle. You do not promote yourself as a purveyor of make-believe. You have branded yourself as someone else. You have branded yourself as something else for the purpose of self-promotion. These facts foreclose the pure opinion defense. Let's see. A lot of this is cut and pasted, which is why I'm kind of scrolling through it. Your unrelenting repetition of false and defamatory statements must stop. And then it gives the same directive as before. Let's see. Yeah. Look, man, it's why these are wild letters. Let's see. We'll do one of the traditional media ones and then we'll go to questions. Let's see. Maybe Gawker. Let's see. And there are others, but they are basically the same. I'm curious as what they're coming after Gawker for. So let's look at that real quick. Well, not curious. I've read these. So, Gawker, editor-in-chief. Dear Miss Finnegan, my firm represents Diana Jenkins. This letter concerns an article by Kelly Conaboy, published by Gawker on June 22, 2022, titled Things May Have Gotten Worse for Real Housewife Diana Jenkins. Specifically, I write to request that you remove the portion of the article that refers to Miss Jenkins as a rumored sex trafficker. See, the problem is there are rumors. The central problem with the article is that it goes out of its way to associate Miss Jenkins with a rumor that is unequivocally false. There is no reason to include a description of Miss Jenkins as a quote-unquote rumored sex trafficker. In fact, the article's false description links directly to an article from E! News that directly refutes these allegations. Footnote 2. Despite being aware of that refutation, Gawker did not include the fact that Ms. Jenkins denied it in the article by repeating a quote-unquote rumor that Ms. Jenkins is unequivocally denied without acknowledging her denial. Gawker is creating the false implication that Ms. Jenkins has engaged in illegal and immoral conduct. As such, the article is per se defamatory. To be clear, any assertion that Ms. Jenkins has ever engaged in sex trafficking is unequivocally false. It looks like these rumors have gotten well out of hand. Like, well out of hand. And how do you shut down the rumor mill when everyone, well, not everyone, when the internet continues to repeat something that is accusing you of crimes? How do you shut it down short of all the cease and desist? Like, what is Diana Jenkins supposed to do? She has done some really shitty stuff on social media, but what is somebody in the public eye supposed to do when something like this just blows up and catches fire? I don't know. I thought Gawker was ruined by the Hulk Hogan lawsuit years ago. They came back. We're going to have to look into, I'm making a note. The Hulk Hogan lawsuit's going to have to go in the bucket. We're going to have to put it on the docket because good God. Because this keeps happening, but I don't know what you're supposed to do. Like, what are you supposed to do? To be clear, any assertion that Ms. Jenkins has ever engaged in sex trafficking is unequivocally false. Indeed, had you sought comment from Ms. Jenkins in advance of publications, Ms. Jenkins would have vehemently denied the false allegation and implication contained therein. Moreover, to the extent that Gawker will argue that it cannot be liable for defamation because it included a link to an article from another publisher that contains a denial from Ms. Jenkins, the argument would be unavailing. First, it is not reasonable to assume that every reader would click through the article. I mean, that's fair. Failing to include the denial in the text of the article itself has the same effect as not including the denial at all. I can see why they would argue that. Second, even if the reader were to click on the link and see the denial, it would be not be enough to absolve Gawker of liability. I mean, the characterization as a rumored sex trafficker, again, I would need more context. In accordance with your legal and ethical obligations as a journalist, we ask that you remove the portion of the article that refers to Ms. Jenkins as a rumored sex trafficker immediately. Please be advised, hey, Fred. Please be advised that Ms. Jenkins reserves all of her legal rights and remedies, including her right to pursue a defamation claim against Gawker. Well, I mean, it wouldn't be Gawker's first time having a defamation claim, that's for sure. But yeah, all of the other cease and desists are of the same ilk, all the same rumors, a variety of statements and how innocuous or not innocuous. Again, Gawker being like, this is the rumor is very different than some of the things said elsewhere, which we can see. So, and that we've read everybody that got their cease and desists. I imagine if apology letters are written, Diana will probably put them up on social media or require others to do so. They are asking them to publish essentially retractions on their shows or content. But man, those are not just those are some heavier statements than I anticipated. Oh, Fred, you're drooling. This cat, when he is happy, just drools. I now have cat drool on me. Hi. The Lawnards would like to say hi. He's gotten so big, y'all. We're gonna have to go to questions. It's time to go to questions. It's just time. Oh my goodness, Fred. We shouldn't have done 3 stories today. We're at 3 hours because I just had to keep talking. But that's all right. It's been a while. I missed you guys last week. So an extra long show. Let's go to questions. I have questions. You have questions. We have questions. It's time to FAQ around and find out. I love that intro so much. And now we're gonna get to questions. We're gonna get to some super chats, and then I'm gonna go get to some lunch, and then I still have to record the podcast, which might be a little late tomorrow because I haven't recorded it yet. I'm sorry. And now we've done a 3-hour live stream. We're just gonna make it hard. We're just gonna make it hard on ourselves. Oh my goodness, that was a lot. This is what I wanted to say about cease and desists, which I talked about. With regard to like BitBoy Crypto and Atozy, and the lawsuit that was filed and then was immediately withdrawn, but without prejudice, meaning BitBoy Crypto could sue again maybe in the proper jurisdiction, but he's definitely spun it like, I didn't mean for it to be public. Once you file a lawsuit, it's public. What a lot of people will do with a cease and desist, not everybody, is also file a copy of the lawsuit, not a filed lawsuit, a draft copy of the lawsuit, and be like, this is the cease and desist. If you would like to keep going, this is the lawsuit that I will file. That is how you keep a lawsuit from being public. You have not filed it yet. But when you file it, it is public. So with that, it's wild. AB asks questions. Do cease and desist demands for remedy find themselves into an actual lawsuit if filed? Some of the demands can, some of the demands aren't legal remedies. Some of the demands can find themselves into a lawsuit. But also, you will see, especially in defamation, like, hey, we told you it was false and you kept going, or you left it up. And they will say, we know unequivocally that you know. So, like we know that you know that this is false because we've told you in a cease and desist and you ignored it. But you'll see people file all the thunder in the like in the Tati Westbrook case with a YouTube gossip channel. You saw 4 cease and desists before they sued, and we will you can see that too where they send multiple cease and desists. So that we're going to get to some other questions. Did you see that Keemstar threatened to sue Papa Gut for defamation? Would you ever stream with Papa Gut? I love watching you both. I don't know Papa Gut well or at all. Also, my streams with guests don't watch them nearly as much. So I can never say who I would or would not stream with because I just don't know. It depends what you guys want. But if there is a lawsuit, I really, always happy to have people's lawyers give input. I really try to not talk with the parties unless the lawsuit is just stupid and I hate it. And then I will make an exception. But look, defamation is becoming such the currency of the internet, right? There's not a great understanding. He just wants to sit on my lap. There's not a great understanding of what is and what is not defamatory. People are like, hey, it's alleged that this and that. That doesn't always work. I mean, that's not always going to keep the defamation lawsuits away, if you will. So it is just. So Fred is just having a floppy morning. Questions. How can multiple cease and desist affect a trial? These cease and desist are all separate parties. So Diana Jenkins would need to file separate lawsuits against all of these parties because they're all acting independently. Each cease and desist represents one potential lawsuit. So those 6, what did I say, 6 or more cease and desists, each represent a lawsuit filed in a jurisdiction where that person is or where that entity is in its own. So how does it affect a lawsuit? Not really. With a jury, you can see them saying, we know, especially in defamation, sorry, now I have fuzz, this is malicious. And we know it's malicious. We sent 4 cease and desists telling them that this was false and they kept going. So it can impact a jury because it's like you had a heads up, you knew it was false. Because with malice, how do you prove that someone knew something was unequivocally false? Them making it up is a pretty strong argument. I mean, that's the argument that Johnny Depp's team leaned into in their defamation suit. You know it's false and defamatory because you made it up. And that's kind of the argument that was implied in some of these cease and desists as well. You've made this up, therefore you know it's false. You have knowledge of its falsity because you're making it up. Essentially what they said. Jake from State Farm. Hey, Jake from State Farm. My Pawner 2 months old beat feline parvo today. I'm so happy to hear that. Parvo can be so devastating. Steve Cass, question, can we go over attorney ethics, in particular attorneys dropping client mid-suit? Is it ethical? Is it legal? Yes, attorneys, well, by drop, you mean withdrawal from representation? Yes, it can happen. Yes, it's ethical. It depends on the context, and it's very specific, depending on context. But a judge has to allow it. So, LAW, random question. Will Emily do a live on Haddish and Spears? I haven't had a chance to read it yet, but it is on my list to look into for Wednesday. I had so much to read while traveling, and there's so much. So yes, it's on my list. So when, I do not know. What Nevada law is Swanson trying to avoid? Joe Jersey, this was the question. I don't know if Swanson's trying to avoid being in Nevada and thinks the law is not as friendly, or if this is just litigation strategy or tactics. I don't know. I don't know why Swanson so badly doesn't want to be in Nevada. Tati was how I found you. Thank you, Mama Glitter Cryptid. I appreciate it. Does spousal privilege apply in civil proceedings? It can, if they were married at the time, but it looks like for some of the period of time that they are seeking discovery, they were not married. So it depends. Question, is there something like a time limit when the lawyers apply for pro hoc vice, or do you apply per case? You apply per case. So it is pro hoc vice for these parties for this case. It is very narrow and specific. So where does this leave the case overall? The Swanson Westbrook case, fighting over discovery with multiple cases in litigation. Oh my goodness. Question, how much trouble can Halo Beauty get into for falsely sponsoring the in-laws for immigration purposes? I'm not, again, I do not have the full context. There are questions about it. If Halo Beauty was sponsoring them for immigration purposes, it depends on what was known and how. It can be a problem. I'm sure it's something they're concerned about. Law and Lumber, here's the problem. Why double down on this argument? Why not just file a motion at the same time to expand the scope of pro hoc vice? I don't know. I don't know at all. Rachel, hello. Emily, I think you need to use that Zoom cat meme that you used before. I mean, at some point, but right now I've got, I am not a cat, but my cat has blessed me with all of his fuzz on my face. Rachel, hello. Hello, Emily, longtime fan. Over the last few months, you inspired me to pursue becoming a paralegal. Today's my first day of class. I wanted to say thank you, Rachel. Let me know how you like it. I'm sure it'll be fascinating. Congratulations. So happy for you. Lindsay said, are they making the father-in-law's medical records a substantive issue? I'm skeptical that there are medical records to support that the specific stress caused the fatal heart attack. Look, lawsuits include a lot of stuff that can be to sling mud. And it again, terribly unfortunate. But I'm sure if they are going that route, that this will all become an issue. KR Thunder, is he just trying to redo his lawsuits in other states? Yes. I don't know why he's form shopping like that. I would love to see some timeline of these things. Like, did they file unemployment after their son-in-law filed? I have no idea. It's a good question. What time would be the benefit of Swanson filing this complaint in multiple states? I don't know what he thinks the benefit is. Truly, I don't. Question, can Swanson claim he trusted the Westbrooks on their word while he was also recording them without their knowledge, allegedly? I mean, it's a fair argument to say, well, if you trusted them, why are you surreptitiously recording it? It's a very fair point. Oh, and they say it's surreptitious. He doesn't. But yeah, I mean, we've already seen him argue that this case properly belongs in 3 different states. So he's made arguments that are contrary to each other before. So I wouldn't be surprised if he continued to do it. Question, what about Lisa Renna suing Patrick Summers for breach of contract if a verbal agreement? Enforcing verbal breaches of contract are difficult. I don't know anything about that. If there's filings, I'll take a look. There's been so much mess in the Real Housewives stuff going on social. I've been kind of out of pocket for the last 5+ days. So if it ends up in court, I'll take a look. Lawn Lumber, oh my God, thank you, sweet baby Jesus. I don't have client meetings. That was a whole lot of DDD in a short period of time. Yeah, it sure was. What the fuck caused these accusations to be made? Is there any evidence of this stuff? Lex, I have no idea where this came from. No idea. Save the cheerleader, save the world. Jonathan, I absolutely agree. And I really hate seeing other celebrities dragged into this with their names. It's just wild. Yeah, it's just wild. It's just wild. I hate seeing that because then it's connected forever. And that's the thing with the internet. Question, did you see that Deaf Noodles apparently got swatted? Birdie, I didn't see that. Swatting is dangerous. I know he's been hosting stuff at a public location where his address is very much publicly available. So, Question, stories from Vegas. We might have to get to stories from Vegas another day. We might have to do that because we've got so many questions to get through. Question, have you seen the Dirty Dough commercial on YouTube? So funny. No, but I'll go look. But I'll go look. Let's see. Midnight, this is my last live for a while. I'm a teacher heading back to school tomorrow. I look forward to being replay crew for the next few months. We love replay crew and we're here for you. I thought Gawker was ruined. I made a note of that because we need to come back for that. Question from Kevin Kimball regarding Tati, who couldn't stay for Q&A but wanted to ask a question. Noelle, that's so sweet. I just want to know if the previously filed suits can be used as evidence in this suit if there are contradictions. Yes, there are ways that, because it's propounded to other courts and signed. So it's like, look, you signed this and you signed this and you signed this. So that, in that way. Question, who is Peter Mon? What is his YouTube channel? I can never find him. I'm sure he's not called Peter Mann. Peter Mon, M-O-N-N. So you can find him. He's YouTube famous. Peter Mon. My in-ears are itching my ears. So question, have you heard rumors of Nene's $4 million payout from Bravo? I have not, though what I would say, if there was a $4 million payout, I would expect the lawsuit to be dismissed with prejudice, not without prejudice. And we saw it dismissed without prejudice, meaning it could be filed again. I would expect a with prejudice dismissal. I mean, they can modify that, but I would expect a with prejudice dismissal. Question, are cease and desist required before suing? I don't know any jurisdiction where they're required. No, you can just sue someone, but I think for defamation cases, they make it stronger. Personal opinion. Did you have fun doing Lawyers and Dragons? Will you do it again? I think I have served my purpose at this point in Lawyers and Dragons. I think Trinity has gone back to other mystical and magical cases. I very much enjoyed it. The group was very, very helpful. It was so early, but it was really fun. And the timing just worked out that I was traveling. I'm traveling so much this month. It's hard. And that's when they started doing it. Hogue was very generous to ask if I wanted to be a part of it. And I said very realistically, I cannot guarantee consistent availability, especially as we get into this month. So I didn't want to feel like I was letting anybody down. And that would stress me out, having additional time commitments beyond the time commitments to this channel, especially for the next few months when I'm traveling a lot. So I was very glad to come in as a guest star. And as things get less busy, we will see. What happened to Elizabeth Holmes this week? I have no idea. I haven't seen anything. Her sentence, I don't know if people filed sentencing stuff. I don't know. Let me see. Again, this week I was conferenced. Elizabeth Holmes asked for new trial citing newly discovered evidence. Well, we will take a look. It looks like they heard the motion for new trial. Here, let me look one more place. It looks like they heard the motion for new trial and then she's bringing something else. So I will look for Thursday. These were older things that were pending that I really wanted to get to. So, let's see. A California federal judge issued a preliminary ruling from the bench Thursday denying the request for post-trial acquittal. They always get made. They regularly get denied. The attorneys told the judge they plan to file new trial motion based on newly discovered information. So if they're filing a new trial motion, we'll take a look and see it. That would probably be filed, actually. This is from the first. That'd probably be filed today. So when that gets filed, we will see. Oh, Yahoo Finance is already reporting that it's been filed. Elizabeth Holmes requested a new trial Tuesday, arguing newly discovered evidence has emerged since she was convicted, according to a court document filed by her lawyers. All right. Well, I will pull that document and we'll go through it on Thursday. So there's a lot going on, apparently. Questions. Are there any special statute of limitations in the Britney case? Have some expired? In the Britney Spears case, discovery is part of it. So I haven't seen anything that I would be like, ooh, this is a worry, because it depends on the discovery, but also Rosengart will get to that. Question, have you seen Inside the Minds of Cats on YouTube or on Netflix? No, I have not. It sounds great, though. Can you please clarify what AH needed to do by September 4th, and did she meet the deadline? Is there an appeal still happening? Thank you. She needed to file, because she filed the notice for appeal. She just needs to file her appeal. I haven't looked at the deadlines in a while. I'd have to pull it up. So no, I can't clarify well. I imagine her deadline will get, or her appeal will get filed. She had 3 months. So they don't need to file the documents yet. She didn't need to file a bond. She had the option to. So I don't think there's any deadlines that have been missed. If there had, trust me, the whole internet would be on ruckus. I have my attention is turned elsewhere. So I have not been tracking heavily Depp v. Heard until the appeals are filed, because there's just not that much. Oh my God, I'm so covered in cat hair. Have you seen that YouTube's getting sued? YouTube is often getting sued, but I have not seen a new YouTube lawsuit. Did you see the ruling on the big Nirvana baby motion? No, I've been tracking it by date, but I have not pulled it up. It keeps getting bounced for quick bits. Hey, lady, hope you are well. Keep up the good work. Well, thank you, Andy. I appreciate it. And thank you for the super chat for this very demonetized video. Question, is there a way for the YouTubers to take down videos that were shared, clipped, that are mentioned in the cease and desist? Can the originating creators get in trouble for those too? That, Joe, you ask a very good and very difficult question. Yes, they would have to copyright claim them to get them down. And if I was Diana's lawyers writing the cease and desist, I would demand that they get taken down. And I'd be like, it's not my problem. You're the one who put it out there. You go get it back. You go make the copyright claims that people are using it, which can be very difficult to do once, especially on YouTube, once they are clipped and re-uploaded. That is the problem. You can't put the shit back in the horse. And that is the difficult thing with all of this. So we will see what happens. But yeah, I would demand it. And if I'm the lawyers for the other parties, I'm like, look, we can't help what third parties have done. We've taken it down. We've issued the retraction or the apology. Question, do we know if apologies were made? I haven't seen any, but it doesn't mean they haven't happened. I haven't searched that hard. How is band mom life going? It's going well. It's a lot of fun. It's been a lot of fun. And my kid loves being in band. It's just been great. Question, what is happening in the Gabby Petito case? This is a question for a different day. I have not seen anything new since the last time I covered it. I covered it in a quick bits, kind of giving an update on where the court was with stuff. So we will circle back to those civil cases probably in a week or two, because I haven't seen anything new. Question, in regards to Swanson claiming that the Halo lawyers will be partially paid by him, wouldn't be the lawyers tracking the time separately, charging only Tati and James? So the company, he's saying because the company's partly owed by him, he's having to pay for Halo because he's partly, he is a part owner of Halo. You can see the time that is now wearing on my brain. He is a part owner of Halo. But yes, there would be like what's going on for Tati and James and what's going on for Halo as the company. Some will have overlap, some will not. Thank you for all you do. Eat and rest. Thank you, Louise. I will be doing that soon. Question, did you catch the new Britney Spears audio where she talks about her son? I heard it as her talking to her son. And it made me sad. I don't know what's going on with the husband. I haven't seen or the ex-husband, K-Fed. I haven't seen the interview. I'm always grateful for your input. Thank you, Laura. I haven't seen his interview. Is it out? Again, I have been so underwater. Michael Toast, I'm using you can't put the shit back in the horse anywhere I can for the rest of the week. I mean, it works. I have been, when I am at conferences, which is why I don't tend to stream while I travel, unless it's like one thing that we're covering. When I am at conferences, I am like kind of in what I'm doing where I'm at. So when I was, out at Cala, I was very much there. Very much networking, connecting with people. They were very long days of talking. So I am not well monitoring, which is even on Twitter, I put a little plain to let people know I am not well monitoring, because occasionally they'll be like, you didn't respond. No, especially when I'm out doing stuff like that. I am very much kind of in what I'm doing and present where I'm at, which is why conferences can be exhausting, because I am very connected to where I am, when I am. And that's what's going to be hard with this week what's going to be hard with this month is the amount of traveling where I am present when I'm traveling, and then trying to also keep up with what's going on the internet, which is why I appreciate all of you when you tag me in things, because then I see them and know what you're interested in hearing. Because again, there are some that came just for Depp v. Heard and we're like, wait, we talk about other things? Yes, we are not dedicated to anything other than pop culture law, but we move on and we have lots of other things to cover that we've been covering for a very long time. So to the question, will I be here Thursday? Yes. And we also should have a members only live. I need to check the date for the members only live. We also have a members only live. We also have stuff launching for the Law Nerd boxes. So I will be talking to all of the members about that. And that is for our top tier members over on Patreon. I'll be sharing that information for all of you about the launch of the Law Nerd boxes. And I will then be running the giveaway after that. So that is what's been going on. Vegas was a lot of fun. Got to meet a lot of lawyers who are covering these cases. Actually met one of the lawyers involved in the Hulk Hogan Gawker case. Met a lot of the entertainment lawyers that end up being involved either directly or as associated counsel in the stuff that we cover. So it was really nice to see everybody kind of face to face. And that was a lot of fun, a lot of connection, a lot of networking, a lot of talking. And it was really good. Had a wonderful dinner with Saltz and Lonnie and their other law firm partner, Jason, where Saltz is like, can we do a tour of the kitchen? And we did a tour of the kitchen. It was delightful. Had a wonderful meal and just, again, a lot of chats about our careers, about law, about the internet. And it was really fun. So I enjoyed it. So the burrito incident, I always do members only live. We do a members only live every single month. So if you've missed them, the replays are up. And I put up, and I'll do it again on YouTube. It was recently just updated over on Patreon too. We put up the list of when the members only lives are, but they are the second Thursday of the month, and they alternate. So we will put up the schedule again on YouTube, but they're every single month, and they are delightful. In addition to the behind the scenes podcast recording, which are sporadic and are kind of the catch you as you will, but those are there. So, Candy's Life, I knew you missed lawyering. I don't miss lawyering. I enjoy having colleagues to talk about things with, but I don't miss the ins and outs of the lawyering. The chatting, I loved. So we very, very much enjoyed the chatting. So let's see. What else? I think that's all the questions I see. Linda, take a moment to breathe. I mean, we're going to do that. We're going to go get some lunch. The KFED interview is with the New York Post on 8/31. Okay, I'll go take a look at that for sure. Have you heard about the lawyer who continued to represent his client after he was fired? Don't remember the name. Rob has the info. Lawyer's gone wild. I will take a look. That can be a problem too. If the lawyer, well, here's what's difficult is depending on the circumstance, you can have a client fire a lawyer and the court has not allowed them to withdraw from representation yet. And that is a problem. So that is a problem. And you can bump into that. But if that's not the circumstance, it's very, very interested. So what about Lisa Renna suing Patrick? I talked about that earlier. If there's filings, I'll take a look. So the burrito incident, no, we do them every single month. So you can find them under the members only streams and stuff in your tab. But yeah, we do them every month and you get notified of them in the community tab. And that's where you get notified of the behind the scenes stuff too. So those are in there every single month. Question, do you think Salty will represent Sharrelle again if a lawsuit is filed? I don't know. It depends on where the lawsuit's filed. Will he come in as associated counsel because it'll probably be filed in Nevada? I don't know. It depends. So he didn't file to leave representation. He just kept sending documents. Well, that's a bigger problem. Once you're fired, you should tell the court and leave. So as a fellow mother, Emily, that interview is going to make you upset. I will take a look, and that's the kind of stuff that I react to in I Have Thoughts. I'm like 3 episodes of I Have Thoughts behind, but that's the kind of stuff I react to over there because it's not really legal documents. It's tangentially related to the stuff that I cover here. And the stuff that is tangentially related to what I cover here goes over on I Have Thoughts on Patreon. With that, y'all, it's been well over 3 hours at this point, and I am hungry. I am hungry. I am hungry. So it's time to go. It's time to say goodbye. Thank you for being here. Thank you for being a Law Nerd. I will see you on Thursday. Members, I will have an update of our members only live stream. And for those of you, I will let you know about the Law Nerd box. I have lots to do today. That's all going to get done after I record this week's podcast. So I will talk to you soon. Again, thank you for being here. Thank you for being a Law Nerd. Okay, bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, LawNerdsUnite.com. Happy to have you. Support what we do here on the YouTube.